I call to order the special session meeting of the Board of Commissioners of the City of Tarpon Springs on July 6, 2022 at 6:30 p.m. Roll call, please.
Mayor Vaticiotis,
Here.
Vice Mayor Lunt,
Here.
Commissioner Carr.
Here.
Commissioner Eisner.
Here.
Commissioner Kulyas.
Here.
Okay, tonight is a continuation of item 9C from Tuesday, June 28th meeting of the regular session. And we've got some housekeeping things to do. First, Mr. Trask, you would like to swear some people in, is that correct?
Yes, I'm going to do that. Anyone that's going to speak tonight on this evidentiary portion of the motion, if you could please stand up, raise your right hand. I'm going to go ahead and swear you under oath. Anyone that's going to speak tonight. Appreciate your cooperation. You swear that the testimony you're going to give tonight is going to be the truth, the whole truth, and nothing but the truth? I do. Thank you so much.
Okay. Another announcement, Mr. Dagnall, our attorney in court, is not going to be with us this evening. Also, I want to just mention the documents that we received today and try and dispose of those early on. We received Concerned Citizen of Tarpon Springs motions for clarification and Morgan's response to that clarification submitted by Ms. Graham in her email dated July 5th at 12:10 p.m. and Mr. McLaren's email dated July 6th at 3:23 p.m. Respectively into consideration, and I'm going to just state that we're going to include that in consideration as part of our arguments. Also, that we received additional documents concerned Tarpon Springs. Documents included Ms. Graham's email, judicial consideration, and that was in the email of July 5th, sent at 12:20 p.m. And then Morgan Group's documents, and also the response included in Mr. McLaren's email of July 5th. That was sent at 5:46 p.m. on July 5th, as I stated, and also another email with additional documents on July 6th at 3:23 p.m. Those will be made, we'll accept those into the record. If you care to address any of those, you'll do it in your arguments. Each of you will have 10 minutes to do so. So with that said, we're going to pick up in this procedures document that we had with item I-8. Mr. McLaren, Morgan Group is up first. Present your evidence to establish the amount of the bond.
Yes, sir. Mr. Mayor, good evening, members of the commission. If I may approach and utilize the computer for a PowerPoint, these documents were submitted previously in June.
That's fine, Mr. McLaren.
Thank you. I know they were blurry. Understand that they may have been blurry, so I resubmitted them. I'll be examining Mr. Salami this evening. Good evening, Mr. Mayor, members of the commission. My name is Scott McLaren. I'm at 600 Cleveland Street in Clearwater, Hill Ward, Henderson. We're here on behalf of the Morgan Group. Mr. Salami, would you take the witness stand, please? And you have been sworn, correct?
Correct. Good evening, Mayor and Commissioners. Sorry.
Could I do a quick housekeeping thing? Because this is an evidentiary hearing, I do reserve the right to object. And so just if you don't mind, if I sit here, I can just jump up.
We can share the
object.
mic.
Okay. Sounds
Your objections noted, Ms. Graham. Thank you.
Mr. Mayor, members of the commission, as stated in our papers, we believe concerned citizens will seek to prevent the issuance of a mandate after the circuit court rules. We believe it will rule in our favor. Also, you know, the circuit court hasn't ruled. Sometimes it takes months for the circuit court to rule, so that needs to be taken into consideration. I'm aware of a petition for certiorari that has been filed with this same appellate panel that has been fully briefed since February, and it's not yet been ruled upon. As presented last time, we believe that at a minimum, the stay sought by concerned citizens will last between 18 months and 24 months at a minimum. Additionally, as indicated previously, The 4.25% interest rate that we're utilizing in our calculations is pursuant to Florida statutes. That's the statutory interest rate. And I put on the board for consideration a document that we submitted back in June. You can see it utilizes both that statutory interest rate as well as a forecasted profit amount, and the 18 months there is exactly like I stated. Now I'd like to examine Mr. Salemi.
I would like to just, for the record, object to the inclusion of this chart into the evidence. It violates 956 summaries of the Florida Rules of Evidence. This is a chart, and they haven't provided originals or duplicates of the data from which the summary is compiled. It hasn't been made open for examination, copying, or both at a reasonable time or place. So I do want to note that objection.
Ms. Graham, if you could, Mr. Salome, if you could just give Ms. Graham just a little space so you can move up to the microphone, Ms. Graham. If you could move up to the microphone and restate that. Thank you, sir.
Mayor, can
Go
you,
ahead, Ms.
point of clarification, Mayor?
Let Ms. Graham finish, and then, go ahead, Ms. Graham.
Yes, thank you, Mayor. I'm objecting to the inclusion of this chart into evidence. It violates 90-956 of the Florida Evidence Code. It's a chart. They haven't provided originals or duplicates of the data on which the information is based, and it hasn't been provided at a reasonable time or place. So there's no foundation for this.
Thank you, Ms. Graham. Again, objection noted. I'm not going to be able to rule on these things this evening without just consideration and taking time out of this process to do so. So this could be dealt with at a later time, but your objection is noted. Commissioner Carr.
Thanks, Mayor. I just want from clarification, I know there's a time limit for each presentation, and if there's objections during the presentations, does the time stop? And then the applicant still continues, or how's that? Just for
That's
clarification.
fine. That's fine.
It has been.
Okay, all right, thanks.
Mr. McLaren, please proceed. Thank you.
Yes, sir, thank you. Could I inquire as to how much time I have, Madam?
8 minutes and 15 seconds.
8:50?
8 minutes and 15 seconds.
15, thank you very much.
By the way, Ms. Jacobs is very good at accounting and just only allowing time that you speak, so without interruptions. Thank you.
Thank you very much, Mr. Mayor. Mr. Salemi, can you tell us a little about yourself, your education, training, and experience, and any licenses or certifications that you hold?
I grew up in Tampa Bay. I went to Florida State University and received a bachelor's in real estate and finance. Thereafter, I received my realtor's license and held that for a period of time, and have since been involved in the acquisition, disposition, or development of $1 billion of real estate, mostly apartments. And I currently oversee $500 million worth of apartment development in Florida.
Mr. Salemi, how long have you been involved with Morgan Group, and what has been your role and responsibilities with that company?
I started at Morgan Group in 2015, initially overseeing discrete tasks within projects. That role eventually grew to oversight of all facets of development in Central Florida.
How long have you been involved with this project?
Since its inception.
That was in 2018, is that right?
Just for clarification, our contract with the land seller is Walmart, and that's as of November of 2018.
All right, thank you, sir. When Morgan was making the decision as to whether or not to move forward with this project, did it prepare calculations on what it predicted the cost would be to develop the project?
Yes, we did, and we made decisions based on that amount, and that amount is $93,936,968.
And is that reflected here on this chart where it says cost basis?
Your chart's a little fuzzy, Scott, but yes, it's at the top.
Right there, 93, 956, 968, right?
Correct.
Okay, and those were developed, that number was developed before the decision was made and before there was any dispute with concerned citizens or anyone about this project, is that right?
Correct.
And you made decisions based upon that estimate?
Correct.
Now you'll see on this chart the word average margin. Do you see that?
I do.
What does that word mean?
I'm going to parse it. Margin is the difference between total revenues and total development costs on a project. So if you have a project that has $150 of revenues and the total cost of that project is $100, the difference is that $50, and we normally state it as a percentage. So in that instance, it would be 50% would be the margin on a specific deal. Average margin is the average of multiple margins.
So it's really a profit margin, right?
Correct.
Okay. Are you familiar with Morgan Group's profit margin?
I am.
And what is the profit margin for Morgan Group as depicted on this chart?
We reviewed the last 10 deals that have been developed and sold or under contract to be sold, and the average margin amongst those 10 deals is 47.7%.
All right, sir. And using the average margin and the total projected development cost for this project, did you come to a projected profit to be earned on the project?
Yes, and that amount is $44,809,116.
All right, sir. Now, given the stay, will Morgan's receipt of those projected funds be delayed, in your opinion?
Yes, if our project is stayed, everything would be delayed. Commencement of construction, when the project is completed, when we can lease apartments, any capital events that would occur at the start or to the end of a project's life.
All right, and using the 4.25% statutory interest rate and the 18 months delay that I described, did you come to a projected loss associated with the delay in your receipt of those profits?
Yes. That amount is $2,856,581. And I would add that that amount is very conservative. Morgan's own internal rate of return is a multiple of that. And so our loss is a multiple of that.
All right, sir. Now, if something happens during the period of the stay that prevents Morgan from developing the project, and the stay is ultimately determined to be the reason for the project not being developed, can you talk about what damages Morgan would suffer as a result of the stay?
I can. To date, we have spent over $3.6 million in design and consultant fees for this project, putting forth an incredibly thorough application to the city and other governmental agencies. We would also have a loss of the $44,809,116, and we would also have the loss of the delayed damages amount of $2,856,581. The sum of those figures is $51,265,697.
All right, sir. Let's step back a minute. When you look at the total projected value of the project, which would be the projected cost plus the projected profit, what project value does that provide?
Well, if we take the total development cost that we've given you, the $93,936,968, and we add that deal profits of $44,809,116, that totals $138,766,084. And so if you take that number and divide it up over the total number of apartment units, you get to $343,480 per unit of apartment value, which I think is low. We have submitted comparables, sales comparables, to the city, and those sales comparables have an average sales value per unit, which is how things are compared, of $369,829. Now, the sales comparables that we submitted are deals all within the Tampa Bay area. There are deals that have traded in the last 6 months. They're all of similar construction type to ours, 3 or 4 story apartment buildings. They are all of an inferior vintage or 2021 at the earliest, of course. And they're all of inferior or equal quality from perspective of the improvements and quality of the site or location.
And are these sales comparables that are on the second page of this submission that was made on June 21st? Are those the comparables you used?
Correct. There are 4 there. Tapestry Lake Park in Lutz, built in 2016. That's a 177-unit apartment building that sold for $355,932 a unit in June of 22. Alta Clearwater in Clearwater, 2021 build, 314 units. That sold in December of 21 for $1,102,250, which is $370,223 a unit. Bainbridge Sun Lake in Lando Lakes, 2001 build, 268 units in total, $340,000 a unit. And then Santos Flats in Brandon, 2021 build, 296 units, and that sold for $404,730 a unit. I think that's more indicative of where the market's headed from a valuation perspective.
Mr. McLaren, can you take a little time and wrap up if you could?
Yes, sir.
Thank you.
Mr. Salemi, did you use this to check the values that you've asked this tribunal for in terms of a bond? And is that your testimony this evening?
I did, and I'll reiterate, I think the values that we've asked for are conservative.
That's all we
That
have.
is-
Thank you very much,
Sir.
Mr. Mayor and
Mr.
Commissioner.
McLaren.
Thank you.
If y'all could just stay there, the commission is allowed to ask questions at this point. And do I have any takers? I've got some questions, or a couple of them anyway. The time frame for the, let me put my glasses on. The time frame for the calculations as far as the value of the project was made, in your decision-making process was when? Early on, 3 years ago, 5 years ago, or can you recall?
I don't want to, wouldn't say years ago. I think what Scott's question was asking was at near the inception of the project. And Scott, please correct
Would it
me
be
if I'm wrong.
current time, current
that?
dollars? Is that what we're talking about, the $93 million that?
The $93 million would be at the time the decision was made, is
Yeah.
my understanding, Mr. Mayor. And then also the margin would vary, that cost would go up, then the margin would make
Okay,
the
but
end value go up as well.
for the record, I think the decision that was made to proceed was in 2018, is that correct?
We make decisions to proceed throughout a project's life. The initial decision to proceed was in 2018.
Okay, but maybe you said it and I didn't catch it. When were these what time frame were these numbers calculated? I think I
understand your-
understood that you said the decision to proceed was based on this $93 million.
The $93 million was projected in 2018, is my understanding, Mr. Mayor. The rest of the numbers
That's all I was looking for.
are subsequent to that.
I'd like to clarify, 2018/2019 focuses prior to the rezoning application.
Okay. And as far as I know this doesn't go into the calculation, but your engineering cost to date, do you have a feel for that?
Over $3.6 million in what I called pursuit costs. So that's design and consulting costs. Just for this commission's information, typically it's a fraction of that. We put together
Okay.
a very comprehensive package for everybody.
That's fine. Thank you. That's all I have. Now, we give Ms. Graham an opportunity to cross-examine.
Commissioner, Mayor?
Yeah,
I have
Oh,
some,
I'm sorry, Commissioner Kulyas.
I do want to clarify with the audience. I did ask through our city attorney that the site planner be here tonight to answer questions about phases of the project. And from what I seen, they are not here today. So I'm going to ask Mr. Salemi,
Yes, or you can call me Camille if you'd like.
say it again?
You can call me Camille if you would like.
Camille.
If that's easier for you.
And Mr. McLaren did bring up how when Camille started with this project, so I want to lead right into what are the next phases of the project?
not trying to be difficult, can you clarify that question when you say
Well-
what are the next phases of the project? The project, what phases specifically are you referring to?
Once you receive your permits, you would have a right to develop the property. What is the first phase? Is it grading, clearing out the land, surfacing it?
So when you receive permits, you would start with your site work first. I think that's what you're referring to. Is that correct?
Yes, sir.
The site
And-
work usually comes before building. You have to prepare the site before you can start constructing buildings.
And how long do you think that's going to be, that site work?
Site work is an ongoing process throughout the life of the construction of the project, but generally speaking, let's say 18 months to 24 months worth of site work.
And you don't have a cost for that site work development?
I do not have a cost with me. I did not anticipate being asked that question, nor do I have a subcontractor signed up to actually perform that work today. That would be when a cost would be finalized. So it's a little premature for that.
Okay, and last Tuesday, Mr. McLaren stated that this is truly unprecedented. If the stay was granted, then we, being Morgan Group, are being treated different than any other rezoning application that's had an application approved in the city of Tarpon Springs. This means we are being singled out and being treated differently, correct?
You're asking me about Scott's comment?
I can testify to that. Yeah, that's what I said. There's never been, to my knowledge, another rezoning applicant whose approvals were stayed by this commission.
Okay, so this is a unique scenario we're in, right?
Yes, it is, we are truly being treated differently than any other rezoning applicant in the history of Tarpon Springs, to my knowledge.
And Camille, you are aware this is one of the bigger private projects in the history of Tarpon Springs?
Is that a question? I believe it to be one of the larger projects within Tarpon Springs.
Okay, now I want to lead into, I want to talk about the inception phase of the project. Mr. McLaren stated, as well as you, that the meeting for the Anclote Harbors project started in about 2018, correct?
You said a
Or
meeting?
The inception of the project started in about 2018, correct?
I said that the contract was executed in November of 2018 to purchase a site from Walmart. And I just want to say, I'm not trying to be difficult. There are a lot of different phases throughout this entire process, so I'm just picking specific points for you in response.
I wanted to ask, who from the Board of Commissioners back in 2018 was part of any meeting with city staff to talk about this project or its inception? And I'm not talking about our city manager, I'm not talking about our planning, solely the Board of Commissioners.
Are you asking me if I met with a commissioner in 2018 to discuss the project? Is that the question? What is the question?
Did you guys meet with any commissioners at that time, at 2018, during the inception or talk about this project?
I had a city meeting initially, and which is typical. You normally come into a municipality, talk to them about your business plan and review what you would like to do on that specific piece of property to get their feedback and reaction to it. The only face that's really coming to mind is Mark. I remember meeting with Mark, and I think maybe Heather was there. Was Heather? I don't recall. I'm sorry, I'm not going to guess. I don't recall who was there.
Huh?
That's the initial meeting that comes to mind.
Were there any Board of Commissioners that was notified about this project from 2018 leading up to the TRC meeting of the project back in 2020?
I can't recall that. It's a little stale. Sorry.
I mean, you are part of the inception of this project, so I would imagine that you'd have a little bit better detail.
We have a term
I
called.
have to object to that. I mean, we were given no notice that this witness was going to be asked questions about, purported meetings with the city commission that may or may not have ever occurred. The email that we received yesterday asked for Cindy Terrapini to appear yesterday. She has a conflict, cannot be here, and there was no indication. The question was about phases of the project. This is not a phased project. There is a procedure under your code that allows an applicant to file for a phased project. This is not a phased project. So we're prepared to answer that question. There was nothing indicating any requirement that we show up with information about meetings with commissioners in 2018.
Well, I do believe when we're referring to phases of the project, the inception phase in which Mr. Camille did refer to,
Mr. Coulier, let me just say, Mr. McLaren, I note your objection for the record.
Thank you, Mr. Mayor.
Go ahead, Mr. Coulier, Commissioner Coulier.
when we talk about phases of the project, inception and starting about the project is one of them. So I was hoping the site planner would be here to answer some questions. Camille, how did Morgan Group find out about this property?
You're asking questions from 2017, 2018. As I mentioned, I'm either have been or currently involved in $1.5 billion worth of development. We have a term called deal merge. You know, there's just, you're working on a lot of things at once. I'm sorry, but I don't recall. I grew up here. I used to play on the site as a kid. I rode around, 3 and 4 wheelers with folks on there back in the day, or would walk it, and I've known about the site since I was, this big.
I used to drive my four-wheelers up on that property too, so I'm familiar with it.
Yeah.
So did anyone reach out to Morgan Group about this property? I mean, Morgan Group just Google it or look on the Realtor website to find it?
Every weekend, I look for sale properties, while I'm just laying around in bed on an iPad. I don't know. I'm sorry. It's just too stale.
Well, why didn't Morgan Group choose the site planning company and the site planner for this project?
Because we think that the land planner, I don't know what you mean by site planner. I'm going to refer to the land planner.
Okay.
The land planner is a highly qualified individual.
Okay. At what point was Morgan Group aware of the immediate family relationship between the owner and land planner of the company chosen and one of the sitting Board of Commissioners members?
I don't recall specifically when, but it was actually, I do remember this, it was well after we started working together.
Would you say this was a unique situation?
I don't know what you mean by that. A unique situation how?
I mean, does Morgan Group position themselves like this in other municipalities by choosing subcontractors whose family relationship with sitting commissioners of that municipality who have to recuse themselves?
I'm happy to answer. What I do recall is when I was notified of this, conflict, I was disappointed. Think about it from my perspective. You have, a certain amount of votes that can vote on a project, right? And if one now has to recuse themselves and can no longer be there, just this situation, generally speaking, any situation, it's less than ideal.
Why were you disappointed?
Because now the number of people that are available to vote on an approval for a project are narrowed.
Okay, so are you familiar with Morgan Group having hire subcontractors who have relatives sitting on commission boards?
I don't know anything about hiring subcontractors because I don't oversee the subcontractors for Morgan Group. I communicate with our general contractor. I can't get into those weeds, sorry.
So would you say this is a unique situation for Morgan Group?
So, I'm sorry, I don't know where you're going with this.
I think that the
No?
witness has done his best to answer the question.
Yeah.
Would you say Morgan Group treated this application different from other applications they have had with other municipalities across the nation with how they hired consultants related to sitting commissioners?
No.
So that is something,
No, I told you I
Other-
didn't know about a conflict when we hired our land planner. I learned about it after the fact, and I was disappointed. It had no influence on when I hired our land planner. Zero. I didn't know about it.
so just coincidentally, you ended up hiring a land planner who,
Who has a ton of experience in the municipality that I want to do business in. That is why we picked her, and because she is damn good at what she does. That's it. There's nothing else beyond that.
Would you say that came with some influence?
What influence? There's none there. If anything, I will tell you the Terrapanis are a champion of this city, and I think they've done a lot for it. That's my opinion, may not be others, but I think the city owes them a lot. They've got a long family lineage in this city, and you know it. And it's not hard work, it's volunteer work what you're doing, right? Time out of your day. You should respect that.
But there was a personal conflict of interest, so there was something to gain from it for the family, correct?
Not to my knowledge. Yeah. I'm done with this line of questioning.
I have no further questions.
Thank you, Commissioner Kulyas. Commissioner Eisner.
Thank you, Mayor. Mr. McLaren, how are you?
I'm great, Commissioner Eisner. How are you this evening?
Always excellent, thank you. I listened to the YouTube. I don't have a court stenographer, so I just want to repeat some of the things that you've said and just follow with me. And if these were things you said, I'd like you to explain it at the end. So you said that you've done the FDOT, the Swift Mud, everything is approved, and you can get a permit any day. You said everything has been filed, everything goes, if everything goes, we are delayed by our stay, was your wording, correct?
Okay, let's take it, I guess, one at a time, please,
Okay,
Mr.
sure.
Commissioner. The FDOT permit, I believe your language was done. I think that I said that we have received 2 FDOT permits, an access permit and a utility permit. And that there was a 3rd FDOT permit, which is a drainage permit. And all the application is final, and we're waiting on an approval that could happen at any moment.
So you also said the stay will cause 40 million. You said the stay will, it's just ready to go. And Commissioner Kulyas asked you about Swift Mud and Army Corps of Engineers, and you said, yes, it's all the permits have been done, and it's any day or any month now. Is that correct?
No, I don't think that's correct. I never said all the permits have been done. What I said, Commissioner Eisner, is that the Army Corps permit had been completely applied for, and we were waiting on an approval from the Army Corps any day. And in fact, we received that permit on June 29th, and I sent it to the commission yesterday. So what I said then, and I say again now, is that we had prepared all the permits and we were waiting on an approval, which we actually did receive one day after the hearing. What I also indicated was that we believed our application for the Swift Mud permit was complete. I think 3 days after the hearing, we received some questions from the Swift Mud. We have now responded to those questions. And so again, we believe we have answered all the questions of Swift Mud. Our application is final, and we are waiting on an approval.
When
So
was
that's what I said then, and that's what I'll say again now, sir.
When was the last time you spoke with the Army Corps of Engineers to follow up to see if your permit is at what point?
Well, we don't need to because we received the permit on Wednesday of last week. We have the permit in hand, the only permit we need to develop this project from the Army Corps.
What did your permit say?
It says a lot of things. It's like a 15-page permit.
But what was it for? It was a permit to build? Was it a permit, what was a permit for, is the
The
question.
permit was for off-site improvements. The Corps of Engineers does not have jurisdiction over any on-site wetlands, so the off-site permit is all we needed to get, and that's exactly what we did get.
I want to share something with you. I spent 2.5 hours on the phone with the Army Corps of Engineers yesterday. and I have to tell you that they spoke completely different than what you just said.
Okay, so are you providing evidence based on your own investigation in this hearing, Commissioner Eisner?
I just am telling you that what they said is not what you said. And if I have to speak about a stay and also about delays and what it can cost, I have to understand that you've done what you're supposed to do. So if they're giving me different information than you're giving me, they're the ones that are the ones that distribute the permit. You do not.
Right, we've provided the permit to you. So do you have any questions about that specific permit and what it says? I mean, I have the permit and I can look at it along with you.
Let me ask, I want to ask the city attorney, am I allowed to speak about what my conversation was?
It's not appropriate, Commissioner. You're not supposed to be doing outside investigation and gathering testimony or evidence in this proceeding. You need to be relying upon the testimony and evidence that's going to be presented to you here. So,
Okay. I'm going to hold off and I'll think this through. Yes.
Vice Mayor Lunt and Commissioner Carr have their lights on, and then Commissioner Cuias has a follow-up. So I'm going to go to Vice Mayor Lunt first.
I just have a couple of questions. You've mentioned several times during the course of the multiple hours of proceedings we've had that it's, excuse me, your constitutional right to develop this property. Is that correct, sir?
We have a constitutional right because we've been approved to pursue the development at this point. Yes, Commissioner.
Okay, so do you have a constitutional right in your eyes to profit?
We have a constitutional right to reap the rewards of whatever the development
That
ends
wasn't
up
my
in.
question. My question was, does the Constitution guarantee you a profit, sir?
I'm trying to answer your question, sir. If you would please allow me to do so, Mr. Commissioner, sir. We have a right to develop the property, and if that development returns a profit, then we have a right to receive that profit. If the development does not turn a profit, we have a right to lose money. Right now, the real estate market is very good, and we believe the evidence will show that we can and will produce a profit on this project. Otherwise, we wouldn't have spent all the money we did spend in pursuing it.
Okay, so let's switch horses a little bit. You've mentioned that basically all in your development costs are going to be somewhere in the neighborhood of $93+ million.
That was what was projected at the time, yes.
What's projected
Commissioner.
at the time. Now, if this stay holds, and you're not allowed to develop this property, what becomes of the, I think you say you're somewhere in the neighborhood of, I'm sorry, I'm going to paraphrase this, $3.6 million into the pursuit cost so far? So we've got somewhere in the neighborhood of $89,000 or $89 million that won't have been spent? Is there no value to this money? What do you do with this money? So if the stay holds and you don't spend this money, this money is not an escrow for this project. You're going to do something else with this money to make profit. Why, in your calculation, should anybody, any responsible party, whether it's the concerned citizens group or the city or whomever, be responsible for profit on money that you have not spent?
Well, that's the way that the development world works, is it's not like you just replace a project with a like-kind project down the road. This is an investment opportunity that we have. We have exercised the opportunity. We have jumped through every single hoop that this commission and this city laid out. We have received our approvals. At this point, we have a right to spend the money and receive whatever return we can. And we don't have to give up this project to go pursue another one. We can pursue this project as well as other projects. So it's not like we can just turn off the light and pursue a project down the street. That's not the way real estate development works. We have the property under contract, we have the right to develop it, we have a right to receive a return, whatever that return may be. Our indications are that the return would be significant.
All right, I'm through.
Commissioner, thank you.
very much.
Thank you, Vice Mayor Lunt. Commissioner Carr.
Thanks, Mayor. So just to come back around, last meeting we, as a board, voted majority to put a stay in place and then did a continuation to this meeting. And this is to hear if we were to establish a bond if needed. Is that right?
Correct.
Okay, so these are the questions that we're asking the parties that are presenting before us. So related to that, the stay was already voted on. We understand that that's already happening. So tonight we're trying to establish if a bond should be put in place or not, and then what that value, I'm assuming, would be. How much time do you believe, and doesn't matter who answers this, is remaining to get all the other agencies' permits? I know you said you received the Army Corps permit. Until you can come to the city and say, here's my book of all the permits. We would like now to apply for our permit. And I don't know, statute, Mark, what that looks like for the city to process it 4 weeks or whatever it may be. How much time do you think that's left?
We have, again, I think, Commissioner Carr, we have 2 outstanding approvals that are needed from outside agencies. The one is for the FDOT drainage permit. The one that is the more substantial FDOT permit that's harder to get is the FDOT access permit to US 19, where they evaluate all the safety and everything. That's already been approved. So the drainage permit we have applied for, we are literally expecting it every day. Our consultant indicated today with Kimley Horn that he was hopeful he might even have it today. We don't have it today, but we're hoping for it any day. The Swift Mud permit, again, we had some questions on July the 1st. We have responded to those questions. That response is in the materials I provided earlier today in response to the motion of concerned citizens, and based on the experience of our consultant who is handling that, we expect approval within, if not this week, hopefully next week. Certainly expect approval within the month.
Okay, so your estimate, best estimate, proposed estimate, I suppose, with all the other permits received and what's pending is maybe 1 month out from today.
We believe, and these are
change.
best estimates. We don't know for sure, right? I mean, they're governmental permits, things happen, so I can't say we will have them, right? I think our best estimate is we would hopefully have all the permits. That's our estimate by the end of the month.
Okay. And at that point, the Morgan Group would come in and say, City of Tarpon Springs, here's our application. We'd like to submit for a permit to move forward on the project. Or is there other processes that go in place where it may be a couple more months or something along those lines?
Our understanding is we would have the right to develop the project and start work immediately upon application and receipt of the city permits as soon as we are done with the Swift Mud and FDOT permits.
Okay, got it. You also proposed like 18 to 24 months. Do you feel that's an accurate estimate for the appeal before the different courts?
I think that that's a conservative estimate, Commissioner. I have been somewhat frustrated recently with the pace of some of the appeals that I'm working on, but I think that's a conservative, realistic estimate as to where this would end.
And your understanding is the stay would encompass any additional appeals to a further court, right?
The appeals, if there is an application to the Supreme Court, could take longer. I'm trying to be conservative. I would hope that if we did prevail at the second DCA, perhaps, at some point the fighting would stop, but can't ever be sure. So, it could be 3 years. Who knows? But
Or it could be 3 months too, technically.
I don't think it's going to be 3 months. It could take the circuit court 3 months. It could take the circuit court 6 months to rule. I don't know. They're busy, and the courts are jammed. So it's difficult. I think 18 to 24 months is a conservative yet realistic estimate. We've tried to be conservative. We're not putting the biggest possible number on the board. We're putting a conservative estimate up because that was what I thought would be appropriate.
Okay, and then for clarity, so let's just hypothetically say one of the court's rules against the Morgan Group at that point, then concerned citizens would be considered, I'm not sure how that's a 1. Does then that null the application that was been approved by the board at that point?
Well, it's my understanding that Concerned Citizens is seeking to quash this board's approval of our project. So if they were to prevail, then our project would come back to you, this commission, I believe, for action not inconsistent with whatever that appellate court rules.
Okay. And then a decision would be made at that point by the Board of Commissions to approve or deny.
Right, and then the commission typically would take into account whatever the appellate court said. If the appellate court said the approval was illegal, then, the presumption is that this board would then deny the application, right? So that's typically what would happen.
Okay, then there wouldn't be loss of money then at that point. Or there would be loss of money invested, but the project wouldn't be lost at that point, right?
Well, if the appellate court were to rule, and again, we feel very confident in our legal position.
Understood, I remember that.
But if the appellate court were to rule that we didn't have a right to develop the project to begin with, then that would be a different story,
Okay.
right? And we wouldn't be seeking any profits.
Understood. Now, thank you for clarifying all that. I appreciate
Sure.
that.
It's a complicated process.
Yeah, thank you very much. I'm done.
Commissioner Kulyas.
Mr. McLaren, at the last Tuesday, you said you believed you need to obtain the Swift Mud permits first before you could receive the Army Corps Engineers permits, correct?
I believe I was uncertain on that. I believe I may have said I'm not sure, but I think that's the case, and I think I was wrong.
Okay, so we clarified that. And last Tuesday, I asked a question about if permitting took 6 months and the court rulings were over in 10 months, then the city would have 4 months of delay exposure, and you replied stating you were not sure. Have you had time to review that topic and elaborate more on if Morgan Group was delayed by the city?
I don't know that I recall that specific question and answer. So let me just say this: if we were delayed 4 months as a result of this board's action, then our position would be that we were delayed 4 months in the return on our investment, and so the 4 months would be the measure of damages, not 18 months. Okay. So that question, I believe, is a yes.
Well, sir, you claim Morgan Group's constitutional property rights to develop and equitable property rights to develop could be violated if this stay is granted, correct?
Yes, we do not believe that Concerned Citizens has proven the right to a stay. The stay, has not gone into effect yet because there's been no order, and so upon entry of the stay, if there's any delay associated or caused by that stay, then it's our position that that our rights are being violated. Yes, sir.
So if Morgan Group were to file a lawsuit, how would the court review our decision? Would it be on a rational basis, an intermediate scrutiny, or a strict scrutiny?
It would be on a rational basis review. Property rights and right to earn profit on land is a rational basis review. I believe it's the issue would be, are we being singled out and being treated differently than any other similarly situated applicant? And then is there a rational or legitimate basis for treating us differently? So that is the analysis.
So if reviewed on a rational basis, wouldn't we have enough reason to grant the stay with or without a bond?
Concerned citizens doesn't have any evidence that they meet either of the necessary criteria for this approval. There is no rational basis for entering this stay.
Okay, and we talk about the potential risk of a market collapse during this period of a stay. Would you say the market in Florida real estate has increased tremendously in this past year?
I believe, yes. I think that it has. I think there are some factors in play now that hopefully it will continue. But if I knew the answer to whether or not it will continue, then I probably wouldn't be here in front of you billing hours to Morgan Group. I would be on a beach somewhere.
I completely understand, sir. So when this project was back in 2020 and, during the inception phase of the project, that Morgan Group had no projections that the market would be where it's at currently right now, correct?
We believed in this market and this city as a good place to do business and a good opportunity to build a nice project and earn a nice return.
Okay, and I just want to ask you, Mr. McLaren, does your law firm represent development applications in other municipalities in which the land planning company chosen for the project would cause the recusal of a sitting commissioner because of a personal conflict of interest?
We represent all types of developers and all types of situations, and I've had commissioners and councilmen and folks recuse themselves from time to time, and the reasons for that are multifold. So, wouldn't surprise me if we had, obviously Commissioner Terrapini did recuse himself, so yeah, I mean, things like that happen, and that's why the recusal, the option to recuse is in place, is to protect situations like that. So things like that do happen from time to time.
Okay, so it was not a unique situation for your law firm to be in, correct?
Not necessarily, no.
Okay, and would you say, once again, this is all unprecedented? We've heard from our attorney, Daniel, that we have wide latitude. Would you say this overall situation where we're at right now is unprecedented, unique, and special?
We certainly are being treated in a unique fashion. So, yes, I believe it is unique in that respect.
Okay, but what about from the inception of the project or the beginning phases of it up until where we are now? Would you consider overall a unique and special situation for all parties?
I don't think the application itself or the approval process that is mandated by your code is in any way particularly unique. Every municipality has different requirements, but I don't think it's like anything special. I can tell you that 23-hour hearings, and things like that are unique. I mean, this is so that's unique. But this is an apartment project, and you have your code provisions that we have to jump through, and that happens in virtually all jurisdictions.
Okay, I have no further questions, Mayor. Thank you.
Thank you, Commissioner Kuyas. Commissioner Eisner, and let's try and make this the last, if we can, to move on to cross-examination, unless you really have another pressing question. Okay, Commissioner Eisner.
Thank you, Mayor. I'm listening to you explain the unique situation. Would you also consider having a planning and zoning board handing a 6-to-1 denial of your presentation go to a 3-to-1 vote on a commission unique?
I think I answered that last time we were together, and I don't think it's
short memory.
particularly unique. Commissioner Eisner, things happen from time to time. There are politics involved. You know, I believe that the Planning and Zoning Commission previously approved this project overwhelmingly and then reversed itself. You know, all types of political and other issues are involved in some of these votes from time to time. So the things I see in local government and the votes and how they change from time to time, I wouldn't say anything is particularly unique. It happens.
In a quasi-judicial hearing, did you find it unique that the current mayor and last time commissioner gave you a complete findings of fact of why he was denying it, and the other commissioners that were voting spoke in generality and were not specific on why they were approving it? Is that unique?
I don't know that's the case, Mr. Commissioner. I don't recall specifically the statements of each and every commissioner at every hearing we've had, so I really can't comment on that without reviewing the record carefully.
So you don't remember that at all?
I remember the hearings. I don't remember the comments of every single commissioner, sir.
Did you mention also that the concerned citizens handed in the wrong protocol to the court, and that's why it got thrown out?
The wrong, I'm confused by your question. What are you asking, Mr.
You
Commissioner?
had mentioned that they handed in the wrong documents, and that's why it was tossed out.
No, that's not what I said, sir.
What
at
did
the
you
last
say?
hearing. I said that they filed 3 very, very, very lengthy petitions.
Right.
And the court threw them all out because they didn't have standing to sue. They could not establish standing. The court also made a lot of other comments rejecting many of their arguments. And I talked about all of that at the last hearing. And so it wasn't like they handed in the wrong document or they checked the wrong box. The court threw their case out because they could not establish that they had a right to sue to protect this property. It gave them another opportunity to amend their complaint, which they've done, and that case is now pending.
Hypothetically speaking, if you did not have all your permits in order and it took 2 years or 3 years, we as a commission would not, the stay would not affect you, correct?
I don't know if I understand your question. I'm having a hard time understanding you, Mr. Commissioner. You're asking if it took 2 or 3 years for us to get these permits that we expect within the month, would that affect the stay? Is that your question?
Pretty much.
Then yeah, I mean, if it took 2 to 3 years, yes, but none of our consultants and no one could reasonably believe that if our application is complete, that it's going to take 2 to 3 years for us to get a permit from SwiftMud.
Thank you.
Thank you, sir.
Thank you. Mr. Salome, if I have the pronunciation of your name correct, if you could stand with Mr. McLaren and let Ms. Graham come up to the podium for cross-examining.
And was this yours?
Oh.
Can you please take that with you?
You don't want a cheat sheet?
I'd rather you have it, actually.
I don't think he understood.
No.
You need to stand over here.
Oh, right over there.
Yeah, I'll be asking both of you questions. So, Mr. McLaren, stick around. Okay, at this point, I'd like to first renew my objection as far as the chart. Mr. Salam has not established, he has not provided a CV, first of all. He has not established the documents on which he's depending on to to provide these statements. He actually had a piece of paper here which he has not provided. And I cannot effectively cross-examine him because of this. I also object to the hearsay that was admitted regarding the numbers in his opinion. He was just kind of randomly talking about numbers that aren't even supported on the document itself. I do have a couple of questions for Mr.
Your objections are noted, Ms. Graham. Please
Yeah.
proceed with a cross-examination, I believe.
Thank you. Mr. Salam,
Time.
do you currently work for the Morgan Group?
I am currently an equity partner and/or equity participant in various deals with the Morgan Group.
Does that mean that you're an employee?
Jane, hang on just a second. I want to make sure you get all your time.
Oh.
So we want to make sure that you're the time is underway. Irene, you have that? Okay.
Well, and just for clarification, the cross-examination, there's 10 minutes for that?
Yes, yes, that's correct.
And, okay.
So maybe about 9 more minutes.
I apologize. I wanted to make sure that we are keeping track.
We're
Thank you.
resetting the time to give you the proper amount past your objections.
Great, thank you. Mr. Salam, do you, and am I saying that right?
You can
Salam?
call me Camille.
All right, Camille.
Thank you.
Do you currently work as an employee for the Morgan Group?
I am an equity partner and/or an equity participant in various deals, including this one. I'm also named in your petition on the seal and the applicant.
So you're not an employee, though? Not, you don't go into work with them every single day, right?
I'm a partner.
Okay. Do you work for anyone else?
I am also a managing partner at Royal Palm Companies. It's common in the development world to have folks that are partners in various deals across various firms.
Are you a designated corporate representative of the Morgan Group?
I'd have to consult with our in-house counsel on that.
All right, I'll take that as a no. Did you make this chart?
The chart that you see today?
Yeah.
I participated in making the chart.
Who made the chart?
Morgan Group?
Did your attorney make? Oh, actually, I will not ask that. You didn't provide any certification or any notice for this chart before, did you?
Our attorney respectfully was the one that handled the submission of that chart. So I can't speak to what was provided beyond what you're seeing.
Okay,
up
and
here today.
is this the type of chart? I mean, you've worked for Morgan Group and other developers. You've got a lot of experience on you. Is this the type of chart that's kept in regularly conducted business?
I don't understand the question. In regularly conducted business, are high-level summaries of valuations kept?
Yes.
Yes.
Okay. Paying property tax on the property.
I have a moment to consult with the witness.
Yes. Ms. Jacobs, if you could just time out for a second.
Property expenses are noted in our PSA, and our PSA has a confidentiality component to it. I cannot speak to that due to that confidentiality with Walmart. I'm sorry.
Morgan Group doesn't have a monetary judgment against concerned citizens of Tarpon Springs. Is that correct?
I would defer to my legal counsel on that.
You've never seen one. I mean, there's never been any case where you have an existing monetary judgment against concerned citizens of Tarpon Springs. Isn't that correct? Are you going to say there is?
I'm not going to say there is either way. I'm going to defer to counsel on that.
Well, I'd like to hear from counsel if you would.
Mayor, if I can just jump in, we've got to maybe keep down the up and down situation. Can we finish with Camille first and then questions for the attorney next? I mean, is there a way we can do that?
I'm actually almost done with Camille, so.
Okay, all right.
Yeah. Morgan Group can't break ground on their project today, can they?
I think Scott elaborated on that very clearly as to what our current status is with respect to permits and timing.
Okay, and again, you don't have any documents with you today that you have provided before or here tonight to share with the commission of the specific numbers that you're, or whoever at Morgan Group has based this chart on. Is that correct?
What you see up there is public information. Any property appraiser will show you that information. The deal names, the vintage, the sale amount, and when the sale occurred, that's all public.
What does total average mean?
Where are you referring to?
On the
Total
bottom
average.
line, it says total average, and I mean, you know, I'm a lawyer, so I'm, you know, officially bad at numbers, but I would think that average means that you take the numbers that are in the chart and then you add them up and divide them, but it doesn't look like that's what that bottom line says. Can you clarify?
So that bottom line has a combination of totals and averages. Under total units, that's the total number of units in that summary. Under sales price, that's the aggregate sales price for all of those deals. Under per unit price, or price per unit as it's listed, that is the average. And that's the reference that most industry professionals will use to compare pricing between deals. Because if you look at a sales price, it's not going to tell you what that average unit is, right? And so that's how you extrapolate value and apply it to other properties.
All right, and you don't have any of the numbers, though, that you've based any of this off. This is just, you know, we're going on you. We Scouts honor that these numbers are.
You can drive by it, touch it, feel it, tour it, and it's public information. I'm not asking for Scout's honor.
Well,
Those are recorded sales.
I'm afraid that that's not enough for including evidence. So I do renew my objection at this point, and I do want to see that that chart stricken from evidence, please. Oh, can I have a
I've
ruling
noted,
on that?
if you're objecting again, I'll note it again. Is that
Okay.
okay?
And you won't sustain or?
I'm
you're-
sorry?
It's just an objection. Excuse me.
I'm noting your objection, Ms. Graham. I just don't know what you want us to do. Remove the chart?
Yes, I want you to remove the chart
I'm not
from
going to
your-
do that this evening.
Okay.
There may be some things that you're going to present that Mr. McLaren may have the same objection to. I just want this to be a fair, and so far we've been very patient, and I very much appreciate that on everybody's part. So if you could just proceed, please. Thank you.
Thank you, Mayor. All right, thank you very much, Camille. I have a couple questions for Mr. McLaren now.
Thank you.
If you just bear with me 1 second. Okay, so, Mr. McLaren, you had submitted yesterday a June 29th Department of Army document. Is that correct?
Yes.
Okay, and that is for 720 square feet of impacts on a culvert extension located under Highway 19 in the tidal waters. Is that correct?
Yes, as I indicated, those are for off-site improvements. That's the only Army Corps permit that was required because the Army Corps has no jurisdiction over any wetlands on site.
Okay. Are you familiar with the jurisdictional determination of navigable waters document dated June 7th, 2021?
Can't say that I am.
Okay. Can I show this to you?
Sure.
Okay, so the Army Corps actually has a jurisdictional determination form that was dated June 7th, 2021. And on this form, it actually includes a number of wetlands, and it says that some of them have tidal hydrology and all this. So you have or haven't?
Yeah, I've never seen this document that you're handing me right now. So what's your question?
Well, my first question is whether you've ever seen that before.
Nope.
Okay, can I please have?
Are you going to ask me questions about it?
No.
Okay.
are you familiar with the Waters of the United States rule and how an Army Corps actually issues a Clean Water Act 404 permit?
Do you have a specific question?
I do, but I want to know first if you're the right person to ask or if you have someone here that can speak to that on your team.
No, I'm not the right person. I'm not I don't work for the Army Corps, and I am not the right person. And when we spoke on the phone yesterday, you gave me no indication that you wanted to ask any questions about this area of inquiry.
All right. Oh, I have no further questions for you.
Thank you.
Are we ready to proceed with your argument, Ms. Graham?
Yes, Mayor.
Before we start, does a commission wish to take a break, or should we continue?
I'm good.
We're good? Please continue. Thank you, Ms. Graham.
Thank you, Mayor. So first, I'd like to speak to the motion to clarify our scope. The scope of the requested stay is actually only 15 days after the circuit court decides this case in the circuit court. This is how the law works under the Florida Rules of Appellate Procedure. And it's not only the law, but it's actually, we are the party asking for the stay. And so that's all we're asking for from you. And we're doing this because we know that that's all that you're able to grant. Morgan responded that Concerned Citizens is trying to game the system and the delay, ultimately the circuit court issuing the mandate. And we would reply that this is pure speculation, and if we were going to ask for a stay on the mandate, that's the circuit court's decision, not yours anyway. And this is very relevant because it affects how long the stay will be and a potential bond. Last week, Morgan and your counsel said it would be 18 months for an appeal up to the next level, the Second District Court of Appeal. And now Morgan says it'll be 18 to 24 months at the lower level, the circuit court. And they're kind of making arguments up as they go along. And it's true. It's very true. Everyone said that we don't know how long the court will take. If they wanted to decide solely on standing, as your counsel last week advised, it probably shouldn't take that long. But we stand on our merits and on our standing. And ultimately, if we win, Morgan will ask the circuit court to stay the order, reversing their approval for Anclote Harbor while they appeal to the Second District. I would also like to quickly clarify the issue of judicial immunity. I think that the issue of liability has come up a number of times, and I want you to know that you are here acting as a judge in a judicial capacity and have judicial immunity for your decisions. This is, as everyone is saying tonight, a unique situation. And the reason why is that the procedure is governed by the Florida Rules of Appellate Procedure. And so in this case, you are handling this in a purely judicial capacity. It's not a legislative policy. This isn't a quasi-judicial procedure where you're weighing criteria in the city code. You genuinely should be wearing robes tonight. This is a judicial procedure. And finally, I want to explain that a bond is not required in this situation, and it was inappropriate when we have been objecting to evidence for a bond. And the reason is that Rule 9.310A of the Rules of Appellate Procedure states that a stay pending review may be conditioned on the posting of good and sufficient bond, other conditions, or both. The rule says may, not must. And if you look at the case law, bonds are typically awarded in cases where there has been a monetary judgment already and that damage can be easily quantified. And here there's no monetary judgment against Concerned Citizens. Concerned Citizens is simply appealing a decision based on the application of the wrong law. And more importantly, Morgan Group cannot show that the stay is causing the delay, as they do still need to apply for permits, any way you cut it. And the purpose of a bond is to protect a non-appealing party like Morgan Group and their rights pending the appeal, but it's not to give the non-appealing party a windfall. And that's actually in one of the cases that they cited, the Capital Development Group case. For that reason, we're asking the commission, acting in your judicial capacity, to award the stay tonight without a bond, but include the condition that the commission may reconvene at a later date to determine an appropriate bond after the final state and federal agency approvals, and the evidence which I'm about to show will show there's still work to be done in the permits. Now, as far as the evidence, I had provided you some documents through judicial notice the other day. They're based on judicial notice because the sources of accuracy cannot be questioned. The evidence shows at very least permitting is not complete and there's still work to be done. The Swift Mud permitting website shows it's incomplete. Actually, one of the new documents that was uploaded on July 6th, which the Morgan Group supplied, was a UMAM sheet. And I know the mayor probably is very familiar with UMAM, which is Uniform Mitigation Assessment Methodology that looks at mitigating wetlands on site. And that would be in your role, just your expertise as an environmental consultant. The interesting thing about that is that it says mitigation area is connected to an area that is historically dredged to create a tidally influenced open water. And the way that the Army Corps permitting works for a 404 permit is for discharges of dredge and fill material into the waters of the United States, which is tidally based water. I've included in the documents a information sheet from the Army Corps that talks about the process for a 404 permit. It takes 2 to 3 months, although it may vary based on workload. Earlier in my career, I worked a lot on Everglades issues with the Army Corps of Engineers as working with an environmental nonprofit, and I can tell you that things, it is a process. I would also say that there is a whole definition in the document I gave you as to the complete application and what is in a complete application. The only permit that you've been provided is a 720-foot nationwide, a nationwide permit, which is basically like a broad brush, hey, like we permitted this a long time ago for all kind of little things, such as 720-foot culverts in the right-of-way. It does not appear that any application has been submitted for the site itself. Concerned Citizens maintains our objection to a bond, as there are other permits outstanding. There's also the FDOT drainage permit, which I believe may also have some questions regarding an Army Corps permit. That's something that would need to be looked at. This stay is not causing a delay. Regarding the evidence put on by Morgan Group, it is unsupported by facts, and it was mere speculation. They've provided no foundation as to the numbers that Camille provided tonight. I'm not going to go back to last week, but I will just say briefly that I think that we have provided ample evidence as far as the quality of our case, and that we have met the standards for the stay, and given that, we respectfully request that you issue the stay tonight, and you can add a condition that once the permits are actually approved from the other permitting agency, that we would be willing to come back and at that point discuss whether or not there should be a bond, and if so, what the number and the damage would be. And all of this is in conjunction with the thought that we're also waiting for the circuit court, and 15 days after that has issued, all of this is moot anyway.
Thank you, Ms. Graham. Is that it with your presentation?
Yes.
Okay. Let's go to questions for the commission. Does Commissioner Eisner, you've got your light on?
I did.
Ms. Graham. Thank you.
Hi, Ms. Graham.
Hi.
Would you be able to elaborate a little bit on the jurisdictional determination that you spoke of earlier?
Yes. Hold on one second.
Sure.
So, Commissioner, and actually, if I may, I do want to make sure that this is proper for evidence. The document that I had pulled up is something that could be judicially noticed. I haven't. It's available on the Army Corps website when you search. And let me see. So there is this document. It was from June 7th, 2021, that actually spoke about the jurisdictional determination form. And in plain language, what that means is that if you are filling in wetlands on a property, and it involves dredge and fill, one of the first things you need to do is saying like, okay, where are the wetlands on the property? And are any of them connected to waters of the United States? And without getting too much into the weeds, there's also a distinction that's currently happening between state delegation of 404 permits for assumed waters, which are not connected to tidal flows, and I think it's called remaining waters or retaining waters that are genuinely connected to a large water body and tidal flows. And in this case, Anclote River would be a tidal water body. And the one last thing I just want to say about that is, you know, this document was issued on June 7th, 2021, while the Trump rule involving WOTUS, or the waters of the United States, was still in effect. And actually later last year, I think it was November or December, the rule was vacated by the EPA. And right now the EPA and the Army Corps are, they're kind of in a position where they're re-looking at some of these determinations, and there's a different standard.
So are you saying it changed?
Yes. Yes, and so, I mean, I would say that this document is no longer good.
Are you assured that it is?
Well, I mean, I'll just say I don't work for the Army Corps of Engineers, so I don't want to testify to their specific policies, but when you read the background, it certainly looks like they would not be enforcing it, and that they would be doing a new rule. A new wetland determination.
Okay. When you made a mention about the time frame that it would take, I think you said 3 months or 6 months for an application, is that correct?
For
the
an
Army Corps?
That's what the Army Corps manual says. It says 2 to 3 months. Whether or not that's true, given current staffing levels, I think, you know, that's what it says. But
Is that for any size project, small, medium, large? That's what I'm asking. Is that any kind, any size project?
you know, that's something that I wouldn't feel comfortable speaking to. If you like, I could take my hat off and tell you that I believe for an Everglades restoration project, it would take much longer than 2 to 3 months, but that's because there are all sorts of other evaluations, but those are much, much larger than generally much larger than things like this.
Okay. So you spoke also about the culvert extension being 700, I believe 720 square feet.
That's right. Yeah.
So is that what we're supposed to view as the permit that the Morgan Group has?
Well, I would say no. I think that it's very clear that the plain language of what the permit says is it's off-site, and it's based on a nationwide permit, which is basically like we're checking the box. It at least looks like from an inspection that no application for the site itself has been submitted. And so, since this jurisdictional wetland issue is also in flux, I would say that it doesn't appear that the Corps has had a chance to even analyze this. Now, it could be that the Corps does look at this at some point once Morgan Group comes back with an application, and they say, you know what, it's okay, actually, you're only building in wetlands, there's no tidal influence, we're good to go. But I haven't seen any of that said. I haven't seen anything in writing. I haven't seen any of those documents provided at this point.
So you're speaking of an application, so there is another application that needs to be applied? Is that what you're saying?
Yes, I would think so.
Okay, because that's what I was kind of trying to figure out and ask. I'm ignorant to this, so I just wanted to know if they have applied for all of the applications and permits that they were supposed to do, or they weren't.
Well, I mean, I would just say to that commissioner that Based on the information provided to me and what is publicly available, I haven't seen anything applied for at this point.
Where did you get your information from?
I looked on the Army Corps website, and I know some people in the Corps as well.
So this is all public knowledge?
Yes.
Okay, thank you. I have no further questions.
Thank you, Commissioner Eisner. Commissioner Carr.
Thanks, Mayor. City Attorney, the attorneys were sworn, right, under oath?
That's
So
correct. They
there's-
all raised their hand. They were sworn under oath.
Okay. I just want to clarify, so your request is to continue with the stay, not assign a bond until all the state permits are received by the applicant? Is that right?
Our request is to have the stay issued tonight and without a bond. And once there are all federal and state permits that are actually issued and everything is good to go, then we're not agreeing to a bond. We would agree to coming back and discussing whether there should be a bond, and if so, how much. And at that point, there can be evidence presented.
Okay. So let's say the court doesn't rule in your group's favor. Do you feel that the Morgan Group would be penalized during that process?
At what point, is this in the hypothetical that a stay has been issued or a stay hasn't been issued?
With a stay being issued, we voted as a board and there's a support as a stay. Tonight, it's going to be finalized on whatever the vote's going to be, if there's a bond or not, right?
Well, I think to answer your question, Commissioner, I think it depends as far as the timing of when the permits are issued. And I mean, I would also argue that, they might have this approval from the city, but they don't have the approval from the other agencies, and so they have no right at this point to break ground or do anything until.
Yeah, let's just say hypothetically, based on sworn testimony tonight by the Morgan Group, a month to receive the appropriate permits by the state and whatever appropriate agencies, and then let's say, I don't know, estimated 4 weeks through the city. Anytime after that, do you think that would be considered a lost then opportunity for the Morgan Group?
Well, I won't testify to them. I mean, I haven't seen anything that they've shown that would show that to me tonight.
Okay, so if a business is trying to move forward with the project, but they can't, is that not considered a impact in their business opportunity?
Maybe, maybe not. I don't feel qualified to testify to the benefit of Morgan Group and,
I'm just trying to understand, because everything that was said by the Morgan Group, you're like throwing up objections and things like that. So I'm just trying to understand. So if the Morgan Group, if the stay was to be, the motion were to move forward with the stay and no bond or whatever that is, what would be the impact of the Morgan Group then, since you put it completely, since you want to object everything that they provided at a high level, what would your number be then?
Well, I don't have any foundation to give you the number of what their losses would be, and there's no way I can, that would be unfair for me to say that, and all I can say is that as long as they don't have apartments for sale and they're not open, I do understand, there is an argument for a delay. I think that's fair, but I think as long as they're still waiting for other permits, I don't think that someone can say in good faith that the stay is causing a delay because they're waiting on something else.
So would you expect a real estate professional or someone with experience in real estate to provide a number that could look like, or?
I think it would be
We'd have the
highly
expertise for that.
speculative, given the current, the current situation.
Again, you've questioned, and again, I'm just trying to get clarification here based on your statements. So you questioned the 18 to 24 months by the Morgan Group. What is your expectation from an appeal through the court system right now?
Sure. So to further clarify as well, what we're asking for, and I said this before, but I want to make sure that you all really understand this. And the only thing that you as the lower tribunal, the commission, have the jurisdiction to grant legally is up until the circuit court issues their mandate, which is 15 days after their final opinion. Now, as long as that, and you know, to see how long that takes, I mean, that could be tomorrow, that could be 6 months. It is very hard to know.
Okay.
And that's why I think in good faith we have said, you know, because we don't know how long the circuit court will take to decide, that's why if all the permits are granted, that we would agree to coming back and saying, let's discuss this, because then there is arguably a causation.
Okay. I'm not an attorney. I don't know if that's the case or not. I've got one attorney that's saying one thing, another attorney that's saying the other. Can I go to our city attorney and ask if that's the case? City attorney?
So the rule specifically says, and I'll read it out loud, a stay entered by a lower tribunal shall remain in effect during the pendency of all review proceedings in Florida courts until a mandate issues or unless otherwise modified or vacated. And I'm reading directly from the rule that was in Concerned Citizens' motion for clarification. So it's clear to me that it provides for all review proceedings and not the current proceeding.
But the important part
Answer
is
your question?
mandate.
That answers my question.
All right,
yes.
thank you.
Yeah.
Proceed, Ms. Graham.
Wait, I'm just to represent
I
what we
think
were saying, the
you've already
mandate.
given your, I'm coming back to you. This is a question and answer type. You've already given your presentation, right?
Well, I did want to clarify, if I could, Mr. Mayor, that our
Mr.
argument.
Carr, allow Ms. Graham to clarify so we can just keep this process moving. Go ahead, Ms. Graham.
Yeah. The argument is that it's during all pendency until a mandate issues, and then we've cited the rule of what defines a mandate, and a mandate is 15 days after an opinion issues. And so the mandate happens at the circuit court, and I've had a case that I've cited. I don't know if you've had a chance to review it, Mr. Trask, or if you
Ms. Graham, let's just stick to answering the question, and Mr. Trask would be asked questions by ourselves. I don't know of a process that would allow you to ask our city attorney a question.
Yes, yes.
Okay.
But yeah, so that is, and I would just urge you to look at our motion for clarification and read it in full.
So what's your estimate then to get through the court system, lower court and the next court? Because I'm assuming that you're going to appeal if the lower court sides with the Morgan Group.
Well, I would assume that we're not going to appeal, because I assume that we're going to win because our arguments have merit. Now that
Hypothetically
said,
speaking then, based on what the evidence has been proposed.
I think that it could be anywhere between this week and 6 months, but that is speculation. That's when the circuit court would, 15 days after they issue their ruling, if either Concerned Citizens or Morgan Group decided to appeal, and then that went to the second district, then that could take a longer time. But at that point, the stay kind of evaporates, and someone would have to argue for the stay at the circuit court level. So your jurisdiction is done, and it would have to have a new stay.
So how many appeals have you done to come up with your justification of 1 week to 6 months over the past year outside of this Concerned Citizens of Tarpon Springs?
I've done 3 appeals, and I've
Okay.
actually won all of them.
And how long did those take?
One of them took a year. The other one was in the first district. Now, the other thing I would say is that they're in the second district, so they're not in a circuit court. So I don't have a comparison for the circuit court in Pinellas.
Okay. And then, so with the stay, I just want to clarify that you don't think there should be a dollar amount to any bond, right? That's what your stance is?
At this point, right.
Okay, all right. Thank you.
Commissioner Carr, is that it?
I'm done, thank you.
Commissioner Kulyas?
Thank you, Mayor. Mrs. Graham, if this board does grant the request to review the bond amount after all permits have been granted, how how long would, and if we granted a bond, how long would it take concerned citizens to be able to put up the money to get it done? What would be a reasonable amount for you, length of time?
I think that depends on the amount of the bond. And the other thing I would say about that is, there are a couple factors. The first is what the capacity is of concerned citizens as far as what they could do to put up the bond. The other issue is actually finding a surety who would decide to, give concerned citizens a bond. I mean, I think, sometimes sureties, they might require higher collateral. They might require, an individual to indemnify a bond. They, could have a range of other issues. And what I would say to that is, concerned citizens would have to, it depends on what it is, and they'd have to see. And ultimately, I do want to remind all of you as well that you issue the stay, but if you issue a bond that's a condition of it, the stay doesn't kick in until the bond is issued.
Okay. What would your argument be for concerned citizens if a lawsuit was made based off rational basis?
Well, I think that I would have to see what the argument was. I think that you have a certain amount of discretion. I would definitely urge you to make sure that your decision is based on the specific legal criteria and the test, which I know that you have very good legal counsel that is ensuring that any decision you make is based on that. And there is, a certain amount of discretion in the rational basis test. I would actually say that, there's a pretty recent case, I think it's from 2017, where Mr. McLaren was actually representing a developer. It's Rickman versus Pinellas County, where they sued Pinellas County on a kind of similar issue in a 1983 claim, and they lost. And they didn't meet the rational, they said that Pinellas County had a rational basis for their decision.
Okay, and would anybody from concerned citizens be willing to put up a personal guarantee of some sort if a bond was asked of this board?
I cannot speak to that at this point.
Okay, and I have no further comments, Mayor.
Thank you, Commissioner Krios. I just have one question. As far as a bond, would the concerned citizens be, actually two questions, would the concerned citizens be filing it as a legal entity? I don't know whether you're a 501c3 or an LLC. I don't know what your corporate structure is, but would it be as individual members or as a legal entity?
It would be as a legal entity, 501c3.
Legal entity.
Yeah.
Okay. And for the record, if I may ask the amount of assets that the concerned citizens have of Tarpon Springs?
I don't have that information with me right now. I could call up Mr. Delacos. I can tell you that I think the last time I spoke with the board about it, it is a small grassroots organization that runs mostly on donations, and it does not have the highest in assets.
That's fair enough. Thank you, Ms. Graham. That's all I have. I don't see any other lights on. Mr. McLaren, your cross-examination, please, sir.
Thank you, Mr. Mayor. Graham, I'll stand up here if that's appropriate.
Sure.
Okay. Is that okay with the
Sure,
mayor and council?
of course.
Thank you. Ms. Graham, you're speaking about the Army Corps of Engineers, and what experience do you have with the Army Corps of Engineers?
So for about 5 years, I worked with Audubon, Florida, as an Everglades policy manager, where I worked very closely with the South Florida Water Management District and the Army Corps of Engineers, lobbying for Everglades projects and WRDA at the state, federal, and DC level.
Okay, you said that the Army Corps of Engineers would be, you thought would be re-looking at this permit? Is that what you said?
I said that I believe that there is a reason for the Army Corps of Engineers to, actually, before I answer that, which permit are you referring to?
The permit we received on June the 29th.
Oh, I wasn't referring to the June 29th permit. That for the 720 square foot culvert, no, that's a nationwide permit.
Right. Nobody's going to be looking at that, this information about how the Trump rules were overruled. That all happened way before 7 days ago, right?
Well, what I would say about that is there's a jurisdictional determination, which I had shown you. That was, what that basically does is it says this is where the wetlands are on the property. That was done June 7th, and it's on the actual site of the Anclote Harbor site. This off-site permit, nationwide permit, that was issued June 29th, that's not on the site. That's on US Highway 19, so it's
Right.
actually apples and oranges.
Let's
And as far as the Trump rule, it had been vacated by the EPA, so there's a process where they're not looking at.
Right, and it was vacated by the EPA well in advance of June 7th when the jurisdictional determination was made. Isn't that right, ma'am?
No, that's not correct. It was actually vacated in December 2021.
Okay. Do you have any information or anything to support a conclusion that Morgan Group is impacting any wetland on site over which the Army Corps of Engineers has jurisdiction?
Well, as I had mentioned, and I will find it,
Isn't it true that the Army Corps found no such impact on site? Isn't that true?
That was based on the June.
Is my question,
prior
is the
wetland.
answer yes or no, ma'am? Would you please answer the question?
Well, the answer is based on the old rule.
But the
They
old
had-
rule is they did look at it and they said there was no impact. Isn't that right, ma'am?
That's right, but at this point, there
Okay,
has
thank
been
you.
no application sent. And also, I would say that the UMAM, I'm trying to find it, in the SwiftMud information that you had provided, there was a discussion of a UMAM rule, and it said, a UMAM analysis, which is about wetland mitigation, and it had mentioned tidally influenced waters, which would at least raise the serious question that the Army Corps would most likely look into such a thing.
Raises a question. Have you spoken, do you have any communication from anyone from the Army Corps of Engineers that suggests that the Army Corps is going to relook at their jurisdictional determination here?
Well, if I did, I don't know if that would be admissible in evidence, but if you like, I'm happy to answer that.
You don't have any information, do you,
I
ma'am?
actually do. I spoke with a lady today who is in the regulatory section of the Army Corps of Engineers in the Tampa office. Her name was, let me see, let me double check. Yes, Adeline Orlando.
Adeline Orlando, what authority does she have on behalf of the Army Corps?
Oh, she works, she is a public information officer who can speak to the specific, what she can do is she looks at the status of an application of what has been applied for and what has not been applied for. And so
Right,
that's
she
what-
doesn't make decisions on whether or not the Army Corps is going to reopen a jurisdictional determination, does she?
Well, that's true, but I think that she, she showed that to date she explained the process.
Okay. Thank you. And do you know, even if the jurisdictional determination was redone, do you have any idea if we're impacting any areas that would even be reconstituted areas of jurisdictional wetlands?
Well, I wouldn't want to speculate to that. I mean, I
Right.
did sit through the meetings, and I think that there were some wetlands impacted, but I would absolutely defer to the Army Corps. I do.
Are you aware that the bond we're here about tonight, that is to cover Morgan's loss if the city makes a mistake tonight. Do you understand that?
Sorry,
That's,
can you repeat that?
yeah, the bond we're talking about tonight, that's to cover Morgan's loss if the city makes a mistake as to the issuance of the stay, right? So the bond is to protect Morgan and really the city as well, right?
I would say that it's to the extent that the stay impacts the delay.
Right, and if it does, then it protects Morgan, but it also protects the city, right? Because the first dollars to be compensated to Morgan come from the bond and not from the city, isn't that right?
I think it depends what kind of lawsuit you're speculating that you would do, and I don't feel comfortable speculating to that.
All right. You said, I believe you said that you represented that this commission is sitting in its judicial capacity?
Yes, that's right.
Okay, it's a quasi-judicial capacity. This commission is not an Article III judicial tribunal, is it, ma'am?
Well, I would actually think that we can agree to disagree on that, because if you think about the authority that we're here tonight, it's under the Florida Appellate Rules of Procedure under 9.310, where you are the lower tribunal and you are looking at something which is through the arm of a judicial lens. I mean, you're not here tonight looking at, these are the criteria that you need to meet in a variance, is it hardship, all that. No, I mean, this is a purely legal issue. And I mean, I think, and we had actually an interesting conversation yesterday on the phone, which, if you don't mind, I would like to disclose to the commission that we do think that the rule probably could stand to be clarified and updated, because we think that it would be helpful for these types of decisions to be held at a circuit court level, at least, where they are such highly legal and judicial arguments.
The rules, the petition for certiorari you filed, that is from a quasi-judicial decision of this body, is that right?
That's right.
And that's under the appellate rules, right?
Well, that's right.
And this body was the lower tribunal under that appellate rule, isn't that right, ma'am?
Well, this stay is stemming from the actual circuit court case. I mean, the writ of certiorari is actually a challenge of the decision, which was a quasi-judicial hearing.
Same appellate rules, same lower tribunal, same quasi-judicial effort.
I would beg to differ.
Yeah. Have you ever seen any case say that a city commission sits as a completely Article III judicial officer?
I have not.
Thank you. The Richmond case you mentioned, that was a legislative decision, not a quasi-judicial decision, wasn't it?
That's right, but they did use a rational basis review.
Correct.
And I would argue that since this is neither legislative or quasi-judicial, and it's judicial, it, still would be under the rational basis review. And, even though it might be painted with a different brush, it's still under the same.
Legislative acts have far more discretion than do quasi-judicial or judicial acts, don't they, ma'am?
Well, that's true.
Are you aware that Morgan has already applied for construction permits from the city?
I have not seen those.
Okay. You had the comparable sales information since June 21st, right? And you had an opportunity to review those sales and determine whether or not they were truly comparable and do your research?
I was provided absolutely no background data, and I don't think it was something that I would have to do background research. I think that since you're up here trying to prove that we need to pay you a bond, you have the burden to show where those numbers are coming from, and I haven't seen you do that.
Right, but for cross-examination purposes, you had this chart that says sales comparables with all the names since June 21, is that right?
That's right, but I don't know where those numbers came from. I mean, those could have been pulled from thin air.
You could have done that research, though, in this 15-day period, right?
Right. Mr.
I think-
McLaren, the 10 minutes are up. If you could wrap it up in a few seconds.
Yes, may I have just a moment, Mr. Mayor, to talk to my partner?
With your partner?
Yes, sir.
Yes, sir, go ahead.
Thank you, Mr. Mayor. For the record, at this point, we would move again to recuse Commissioner Eisner from these proceedings based on his independent research and earlier testimony concerning same. Thank you.
You're making a request at this time to recuse Commissioner Eisner from further participation in this matter at this point.
Based upon his admission that he did independent research, which is our grounds.
Okay. What I'm going to do is take a very brief recess for about 5 minutes, or actually, let's reconvene at 8:30 to give people a chance to break, and I'm going to have a chance to speak to the city attorney about this. We'll reconvene at 8:30. 1 p.m. The business at hand is a request from Mr. McLaren for Commissioner Eisner to recuse himself. I've spoken to the city manager. And, I'm sorry, city attorney. Let me ask Mr. Eisner, there's two things we need to do. One, I want to ask Mr. Eisner if he has done some investigating or pursued seeking information on his own. And as I'm told, that's not appropriate in these types of proceedings. And so my question to Mr. Eisner is, do you believe that the information you gained on your own outside these proceedings can be set aside and not influence you on any formal decision this evening?
That would be correct.
That's yes?
Yes.
Okay. Mr. Trask, based on that, I don't see a need for Commissioner Eisner to recuse himself. Do you see anything beyond that?
He needs to make that decision on his own, like we did at the last hearing, whether or not he wants to recuse himself or not. Based upon the answer that you just give, I assume, Commissioner Eisner, you're taking a position you are not going to recuse yourself.
I am not going to recuse myself.
All right. Thank you, Mayor. That's what we needed.
Thank you, Mr. Trask. Thank you, Commissioner Eisner. Secondly, I should ask whether any commissioners had any ex parte communication since our last meeting that they'd like to divulge?
Yes, Mayor, I did have a brief conversation with Peter Delacos at the 4th of July picnic in which he did email me some documents that were all related to the backup, that are all in the backup, in which I did send to the city attorney. And I did receive a couple texts regarding the Army of Corps engineers number. I never contacted them, and I did not reply back from Mr. Hrabowski, and that is it.
Okay, thank you. Is there anyone else?
Yeah. I also received a text message from Mr. Hrabowski regarding checking out permits. I did not.
You did not act on those?
Pardon me?
You did not take any action on those
I
text
did not
messages?
take any action
You did not
to
respond,
determine
okay.
the status
Similarly,
of any permits.
I'm not sure what the date was, but I received a couple of text messages with some phone numbers. I'm presuming they were an 813 number, so I would assume they're the Army Corps. I did not utilize them, did not respond to Mr. Hrabowski's text message on that. And that's, by the way, there was a public records request, and at least the information that I've just stated is in that public records request that the Morgan Group had requested. So does that satisfy the issue?
Yes.
Okay. All right. So we've finished with the cross-examination. Now it's time to go to public comments. Do we have any public comments this evening?
First, I'd like to state that there were several people that offered to donate their time to me, and I don't recall the exact number. How many people do we need to stand up right now to get the maximum amount of time? I'm asking because I honestly don't know.
You mean for additional time?
Correct.
The normal procedure at this, it's the normal procedure, which is 4 minutes plus 2, so it's 6 minutes.
So how many human beings need to stand up and donate? Are they
All you
donating 1
need
minute?
is one person to give
Just
up
one
their
person.
time. Right.
So whoever it is.
Thank you, Ms. Crosado. Proceed, Mr. Hrabowski.
Chris Hrabowski, 1602 Gulf Beach Boulevard, Tarpon Springs, 34689. So Attorney Jane Graham gave you guys the easiest out of all time. No harm, no foul. If they're so sure they can get their permits in a month or so, then why would you give them a bond? For what? I mean, she said if they get their permits, then she'll come back and talk about doing a bond. But there's absolutely no reason to give it to them now. And, you know, Clay Colson and Leslie Blackner sued the U.S. Army Corps of Engineers and beat them in federal court over this NWP stuff, this nationwide permit, because they were handing them out like candy. So we will be reminding the Army Corps of Engineers of that, like we did with Walmart. Guess what happened in the Walmart days? We got Walmart's permit revoked They had to start all over again. So guess what? Once we remind them to, oh, you guys should really look into that little culvert thing that you just granted. Because, oh, there might be a few I's not dotted, a few T's not crossed. We're going to do that. And oh boy, they sure play fast and loose with the truth, don't they? Acting as if those wetlands on there are not jurisdictional by it. That's just laughable. Of course they're jurisdictional of the Army Corps, and hundreds of people from our town, citizens, have called the Corps. And they know now that it's game on. And they're going to make sure this process is lengthy. That's what they do. There's a comment period. Let me remind you, the guys that are helping me, the experts, they held up the Ridge Road extension for almost 20 years, just with comments. 20 years. So you don't need to give a bond to these people. Look, they ain't going nowhere. This thing is gonna screech on the brakes. The Army Corps is now upset that they're down here telling you guys fibs. And so they're gonna fix it. And whatever we have to do to make that happen is already being done. And Clay Colson, who beat the Army Corps in federal court, he sent something to the 2nd DCA today, got there at 6:36 a.m. So his case is also going to be lingering on. So even if the concerned citizen's case gets settled, either way, this other case goes on. And it's going to the Florida Supreme Court because our city attorney took it upon himself to take a stand in your names and the name of everybody in this town that says that, lowly little people don't have First Amendment rights in court. It's so ludicrous. He should have asked you guys to vote on whether or not you would approve that language. But he didn't. He just went ahead and did it. And he cited a local rule that's just a joke. So the Florida Supreme Court is the next stop. And then maybe the U.S. Supreme Court, which is where this can ultimately go. How long do you think that's going to take? A couple months? No. It's going to take a while. And that's not anyone's intent. That's just the way it works. It's the way the system is. So let me tell you something. You don't need to give them a bond, not at this juncture. Let's wait 10 years and see if they can't get their core stuff through, and then maybe we'll talk about it. But until that happens, they get nothing. And you still have time to settle Mr. Colson's case, That 30 days hasn't passed yet. Morgan Group isn't even a party to that case yet. It's just you and Colson. You guys could do that, take care of it, make this whole thing go away. You won't see my pretty little face down here anymore. So that needs to be seriously considered. And get your city attorneys to put in writing, in the form of an email or a memo, why he won't do it, why he won't settle that. Put it in writing why he won't settle the case and pretends that it's not a real settlement just because there's no money involved. I'll bet there's some money involved, all right. Yeah. But Mr. Colson's not asking for any. But let me tell you something. If this does go any further, Mr. Colson can file a multi-million-dollar lawsuit against the city for infringement upon his First Amendment rights, which didn't even have to happen. It was moot. It was not relevant at all to what the city was supposed to be doing in court. Not to mention that the 163 case that Mr. Colson filed is rock solid because that thing, the development order was granted inappropriately, and you all know it. So he's going to prevail, whether or not concerned citizens. It's a lot to think about. Do the right thing. Thank you.
Thank you, Mr. Bobrowski. Next speaker, please.
Mr. Mayor, Commissioners,
Good evening, Mr. Carter.
good evening. Tex Carter, thank you. Needed that reminder. Tex Carter, 1810 Mariner Drive in Tarpon Springs. I listened to both parties tonight. I do agree that Attorney Graham has given you a really good solution for tonight. It's one that allows you to go ahead and put the stay in place, let Morgan Group do what they say they are going to do around permits and getting the approvals necessary to stage their city permits. No grubbing, no clearing, none of the site investigation work, none of the site changing work will take place until that happens. Then you come back, and if all the permits are in place and all the work is done to be ready to do the city permits and to start preparation for construction, you can have that hearing at that time. It's a great solution. Wish I'd thought of it. I've spent 50 years in engineering and construction and built 10 times as many projects as Camille claims, and I do hope you get there, buddy. Okay, a good career is a great thing to have behind you. What I do know about developer projects is that developer projects, when they do their estimates, they build in risk, and risk includes permitting time, it includes changes in construction plans, it includes all kinds of things that they're now asking a bond to indemnify them from that risk so that they're not having to take the risk and they can go ahead feeling like abandon the project because we were delayed, we get some money and we're okay. We don't feel like the citizens, concerned citizens of Tarpon Springs should be footing that bill. We think developers take a risk when they build a project. They told you how much money they could make if all the risks go away and if the project is successful. This is just another set of risks that they've priced into their project already. They don't need a bond to relieve them of that risk. I think I'm through. Thank you, guys.
Thank you, Mr. Carter.
Brian Crosado, 616 Palm Avenue. Just want to bring up something. We have the ROI up here, what they intend to make. There are a lot of things standing in the way. The economy is getting ready to slam shut. Labor costs are very high. Construction costs are very high. They could go bankrupt trying to build this thing. So why are we have to gamble and put up money against what may not happen, may not finish? Many construction companies go belly up. So it's just a thought. Nobody here has mentioned that, you know, maybe it won't be successful. Thank you for your time.
Thank you, sir. There are any other public comments this evening? Yes, ma'am.
Beth Hovind, 1996 Whispering Way, Tarpon Springs, but not a citizen of Tarpon Springs. I live in the county, no man's land, but this is my post office box. I have written several letters to the commissioners over time about this development at Anclote Harbor, and I've been concerned for two reasons. One is the environmental impact, and secondly is the traffic impact, which I don't think either have been resolved at this point. So I am concerned that it appears developers seem to be presenting the opinion that they have a legal right to do anything they want to do within Tarpon Springs. They can sue us. They can push for their peace of mind. They can even require that a group of concerned citizens, regular people in the city of Tarpon Springs, should have to put up money to be able to take them to court for what they feel are irregularities in the process. I think most of you on the council or on the commission were elected with the premise that you're also against this project. And I think that that is probably why you're in those seats. And so I'm asking you two things. One is to do what you can to keep this area pristine. And secondly, not to put the burden on citizen groups who come to you impassioned about various causes, the environment or something else. Put the burden on them to have to put up money to be able to present their issues. That's all I have. Thank you.
Thank you, ma'am.
Peter Lex, 514 Ashland Avenue, and before we start the clock, Miss Annie Samarkis has been willing to donate her time to me. Okay, first let's clarify a few things. At approximately 9:17 on June 28th, Panayoti Koulias began questioning Mr. McLaren. And these were the questions that were, I'll paraphrase, as Morgan Group obtained a Swift Mud ACE permit. Mr. McLaren said should be done relatively soon. And then Mr. Panayoti said, Ed, on the Swift Mud board, is that an influence? And then this is where he asked if the Army Corps of Engineers is dependent on the Swift Mud permit. And Mr. McLaren implied after speaking with someone that he thought it was. And then the discussion was, how is it you don't know about the process, and said's on the Swift Mud? And then that's where Mr. Panayoti directly asked, if the Swift Mud permit is to be done in 6 months, but the legal issues are 10 months, how is it that the citizen should be required? And Mr. McLaren didn't answer directly. He kind of went off into some other things about the 1 and the 2 rules that should be applied to and things of that nature. So just want to brief you on that. Now, also on page 10 of the Morgan Group's response, we keep hearing about this Rule 9.190.E3, which has been read and read and read, but again, I'm going to repeat it. A stay pending review may be conditions on the posting of a good and sufficient bond, other conditions, or both. There is no requirement to do it, yet on page 34, in their closing about the bond, in highlights bolden, if necessary, Morgan will present testimony and evidence as the hearing as to the amount of the bond, including that the minimum amount of the required bond must be at least blah, blah, blah. Well, it's not required. They've misrepresented to you again, and again. So, as I stand before you, we don't feel that a bond is necessary. We've shown you from evidence presented that permits are not likely to occur anytime this week or anytime this month. As many of y'all said at the last hearing, you aren't attorneys. Let the court decide and come back with their ruling as to the case. The Morgan Group keeps implying that we have no case. But if after we submitted all of our documents on April 25th, if the court didn't think we had a case, they would have pretty much already let us know by now. So now we're over 2 months since we finalized all our documents. So to me, that shows they're at least, if not having looked at it, are willing to take the time to do so. Now, concerned citizens, who are we? We are some of these people here who have taken the time to come out to show you that they support your decision on moving forward with a stay and without a bond. And why is that? Because these people, and you know for months, we had yard sales and handing out flyers for donations. We're a small groups organization fighting the Morgan Group. 20,000 apartments over 5 states all over the country. If they have plenty of cash flow. And I sure would like to hear some discussion about how you really value a project. Because technically, I am a licensed real estate sales associate, voluntary and active. I take my CEUs every 2 years. And the way you really value projects, if you plan on keeping them, is on cash flow and expenses. What they're providing you are comparable sales. That means they planned on flipping it. Yet, how many times over the course of the years, this last year and a half we've had hearings, they said, oh no, we want to be members of the community, we're going to be here, we're here for the long haul. Yet the evidence they provide you for the valuation is based on selling the units, flipping it. So they're wanting to charge us for their delay and flipping the units. And yes, I agree, the property market is hot. I get the Business Observer. Every week there's another apartment complex that's being bought by another outside unit for 30%, 40% more. But things are changing. So I can't predict, and neither can they, predict their profits or their losses. So at this time, we put ourselves at the mercy of this court. We represent your citizens. I disagree with their statement that we don't have harm above the citizens. Well, we are the concerned citizens of Tarpon Springs. We represent the citizens that you represent. And they are saying to you, let this proceed and don't put something on us that stops the process from getting to the truth. Thank you.
Thank you, Mr. Delakis.
Good evening, Commissioners, Mayor. My name is John Kolianis. I live at 1020 Peninsula Avenue, and I am a CPA. I'm also a certified business valuator, and I hold the designation of a master analyst in financial forensics. I have experience in calculating and analyzing calculations of opportunity losses. Most recently, I was hired and testified for the city of St. Petersburg, and one of several engagements hired by them. I just want to give you some information as you guys deliberate on this matter and in helping you to make your decision. Also because you've got to kind of decide some financial things, and that may not be your bailiwick, but it is mine. The first thing we do when we're analyzing a potential loss, and that's what we're talking about. We're talking about a potential loss, is you look at the methodology. You look at that methodology and you ask whether or not it meets a standard of an acceptable and relevant methodology. So you have to ask yourself, and a lot of it's understandable reason, right? Do you understand the rationale and the reason behind that methodology? And let me make it perfectly clear. I've done no analysis on this matter, and I'm not making any determination of anything on this matter. I just thought, given that I have this experience and that I'm a citizen of the town, that I might want to just share a little bit of information with you. So the first thing is we look at standard. But equally as important, we look at application of the standard, the application of the facts. All these things are based on assumptions. None of us know what's going to happen 30 days from now, 6 months from now, let alone 18 months from now. We don't know that. So you look at, again, at the reasonableness of the application of assumptions. It's appropriate to apply any factors that might mitigate the potential loss. Like you guys talked about possible delays in additional permitting and things of that. That's a fair, you would want to take that into consideration in reducing and looking at the reduction of the potential loss. You also have to look at when I'm doing an analysis, especially like the one I did for St. Petersburg, is I had to look at the underlying data, right? You were given profit margins. You'd want to see how those profit margins were calculated, right? Those are sometimes broad when we look at the words profit, net income, gross profit. There's all kinds of terms, but those terms, I always want to zero in on how did we come up with those percentages. And so that's really important that we have that, and we know what costs were included in calculating those percentages. When we're using something like a market method, kind of a market method that was used here, it's often best to have a large sample, right? I like to have as many potential opportunities and samples in my decision making, because it smooths out a lot of things. Because we don't know, there's lots of things you don't know when you have a small sample. You don't know where they are, what the locations, the kinds of buildings, all those things that could come into play that could have an effect. But when we have large samples, then it kind of smooths out all those things. So,
Mr. Koulianis, you're out of time.
Is my time up? Okay.
Mr. Landrum? Mr. Landrum's giving you 2 more minutes.
Well, thank you. I don't think I'll need
Landrum.
I don't think I'll need it, but thank you so much. Anyways, I'm here as a citizen that happens to have experience in this matter, and am just sharing, when you go into your deliberations, that you look at methodology, application of methodology, and assumptions that are made, and what are those backups. And if you don't have the backups, that's difficult to make those kinds of, to understand or to be able to rely on those assumptions. So, thank you.
Thank you, Mr. Koulianis.
Good evening, Barbara Walker, 3019 Bradford Circle, Palm Harbor. I'm a member of the Concerned Citizens, and I just wanted to say that whether you are coming from a position as a commissioner or as a judicial, from a judicial perspective, that the goal is to make a fair decision. From what I see every day, and even what I've heard just tonight on all the different projects and things that go on, I think that the only way to apply environmental justice and social equity here is to grant the stay without a bond. That's all I have to say. That's my request this evening. Thank you.
Thank you, Ms. Walker. Is there any other public comments?
Jackie Turner, 792 Chesapeake Drive. As many have said, I also do agree that the bond requirement of keeping this stay doesn't fit. As was noted, it does say that that stay pending review, what we've got, may be conditioned on a bond. That's not a requirement. This isn't something set in stone. So something to think about is, I realize, yes, and respect that, you know, the business here with Morgan Group, they have fronted some money. That's the nature of doing business. Real estate, there's some speculation there. You're making an intelligent decision, but you also know that you're going into this, that you've got to put some money up. You may make a lot, you may lose some. So that's the risk that they have determined to take, just being in the business that they're in. Why do you want to very unfairly and just harmfully penalize concerned citizens of Tarpon Springs? Because they're not comfortable taking the basic financial risk. That's the nature of their business.
Thank you, Ms. Turner. Are there any other public comments? Okay. Mr. Jump, are there any remote access comments?
If anyone online would like to speak, please raise your hand and you'll be allowed in to talk. And we do have raised hands, so I'll allow the first attendee in.
Thank you. Those that are going to be speaking remotely this evening, you have 2 minutes for your comments. Thank you.
Hi, hello, thank you. My name is Randy Myers. I live at 13. Can you hear me? I guess I should ask.
Yes.
Can you hear me?
Yes.
Yes.
Okay, thank you. My name is Randy Myers. I live at 1389 Sail Harbor. I'm a Sail Harbor resident. That's upriver and around the bend from this project. I am a member of Concerned Citizens and the Friends of the Anklet. We'll remind the team again, we are a grassroots organization that has identified, we think, a number of issues in the project application process that render the process incorrect and thus really not complete. And we think it must be revisited and corrected. And as you know, there's a lot of effort, many irons in the fire regarding that. And thus including us asking you for the stay. And I wanted to thank you for the Board of Commission for the stay decision. We have no profit game in this. I am uncertain that or why a bond is required. As a member of this Concerned Citizens and Friends, I'd appreciate if no bond requirement was placed on this stay. I think you've heard a lot of good arguments from our peers as to why that is as well. So I won't spend any more of your time. Thank you.
Thank you, sir. Mr. Jones.
I'll allow the next person in.
Thank you, sir.
Yes, thank you. Can I be heard?
Yes, if you'd state your name and address for the record.
Certainly. It's Robert Rockline, 755 North Lake Boulevard in Tarpon Springs. And I would bet that I am a concerned citizen. I live about a Tiger Woods Drive and Iron Fairway shot away from the border of this property from my front door. For the last 19 years, I've been a building official for various jurisdictions. And I've never heard of an applicant requiring a bond from either the jurisdiction or other parties. If anything, it's a bond required from the applicant for any unintentional or negligent harm or damage to any public or private property that's off the permitted site. I don't know if the Morgan Group or Walmart has posted any sort of bond for this or will be required to, but the scope of this project, whether it goes forward or not, would certainly warrant that based on the size, the location, the associated public safety and environmental concerns. I know developers, they look for the path of least resistance. If it was up to them, they'd apply one day and bring out the hammer the next day. But like other speakers said, this is a voluntary venture by a private party. So it's their job to perceive the risk versus reward and any balance therefrom. They should be anticipating delays, whether it's something out of left field like supply chain issues or inclement weather or a hurricane. So, their request for a bond, I think is ludicrous, to put it lightly, in this case. And the concerned citizens stand more to lose in the big picture if this goes forward than they do. My only other question is, and I'm not sure if it's been answered in prior meetings or prior investigations, do we have any proof of the Morgan Group's ownership of this parcel? And if so, when did they take possession? How much did they pay for it? And if they didn't, is there any effect in their participation throughout this application process? Because if there's some illegality in there, I'll fly down tomorrow and give them a kick in the pants. I think that should be thoroughly investigated to find out when and if they took any ownership in this, or are they just acting as the agent of the owner, which is probably still Walmart from everything that I've heard and searched online. Thank you for the opportunity to comment.
Thank you, Mr. Rockland.
And we do not have any other raised hands at this time, sir.
Thank you, Mr. Chump. We have one, we received one email that does not quite relate to the bond, but it's related to the item. I'm just going to allow some liberty to have that read into the record. It's a brief email. Ms. Jacobs, if you could do that, please.
Yes, thank you. This is from Andromahi Nicola, 1398 Cell Harbor Circle. I am deeply concerned of the irreversible destruction to the beautiful ecosystem that this plan of greed will cause. How much more destruction must Tarpon Springs encounter? Visitors and residents are drawn to the area for the natural beauty. Enough of the destruction of the natural ecosystem. You will destroy the beautiful wildlife, and soon Tarpon will look like a sea of houses with no natural beauty. Might as well be another disgusting, desolate area like California. Any member voting for the destruction of the natural habitat is nothing more than fulfilling financial gain and greed. Look around and look at the destruction of the greedy builders have done to US 19. Looks like the project in the inner city. Is this what you want Tarpon Springs to look like? Put your greed aside and think of the natural habitat that can't be replaced. Ecosystems are an important part of the environment. Please put a halt on the destruction. And that's the only.
Mr. Jacobs. That ends the public meeting. I'm going to close that now, and we're going to go to commission discussion amongst ourselves. We've got three choices for this evening. One is not to require a bond. Secondly, to not require a bond with a condition to meet again in the future after certain conditions are met. And then thirdly, a bond for a specific amount and a time frame for which to obtain the bond. And if we go that route, then we're going to recess for 30 minutes to go over the numbers that the Morgan Group has given us to determine the bond amount, and also the other evidence concerning the time frame for obtaining permits and things. So I'm going to go ahead and go to, I'm going to ask each, I know Commissioner Carr's got his lights on, but I'm going to start down with, from a seniority perspective, and go Vice Mayor Lunt first, please, if you have any comments.
Yeah, actually, I have a few. My apologies if they're not exactly cogent. I've been kind of trying to put them up while we've been talking. Morgan Group is pushing around a lot of figures, a lot of large figures. We're talking, you know, somewhat of an alleged 51,000 or $51,255,612 in possible losses that might occur should this not happen, should the Morgan Group not happen, or the Antelope property not be developed. My thought is that they build risk into their proposals. They build risk into everything they do. They have probably built risk into this project as well. I wouldn't be surprised if they had reevaluated that risk given the circumstances of the last several months. Also, I think they're giving us what may be their perfect figure. As Mr. Koulianos explained, there's not a lot of detail behind the numbers that they've shown us. We have to sort of take them at their word that there's enough substantiating evidence behind that to require or to come to those figures. They mentioned their pursuit costs so far are $3.6 million. I would suggest that that $3.6 million to a large part would be something that they would know was at risk in a pursuit cost, because I'm sure not every deal they pursue comes to fruition. So there's that. They mentioned they've already applied for permits from the city. I want to bring attention to the fact that the resolution, I believe it was 2021-60, has a section 5 which says not only are you responsible for obtaining our permits, but all applicable permits from all other agencies, and you also have to meet the minimum requirements of our comprehensive zoning and land development code. This means that we once again are going to have to determine whether you're meeting our comprehensive code. And I'm you know, that's for a different discussion. There's been some valid arguments on both sides. My personal feeling is that this is far exceeding what we really wanted to get into as a city commission. I think we should not require a bond. I also think that we should let it play out in the actual court. So until the court mandates that concerned citizens has no standing and that their writ is again refused, I think we should just leave it at that.
Thank you, Vice Mayor Lunt. Commissioner Carr.
Thanks, Mayor. I've got a couple questions for the attorney. Is that okay?
You have questions for the attorney?
Yeah. City Attorney, thanks for being here tonight on a special meeting. If a bond is required, who's the bond protecting in this situation?
The bond, first of all, protects the applicant developer and then possibly the city of Tarpon Springs.
When you say possibly the city of Tarpon Springs, is there a risk that the city could be litigated against?
I think my partner had addressed that at the last meeting, that there is some exposure, yes.
Not individually, but as a board or the city, right?
Correct. Not as on an individual basis as the mayor, vice mayor, or commissioner, but as the city as a whole.
Okay. Would you think there'd be a less risk if the board were to move with no bond until all the permits from the regulatory boards and state agencies were received, and at a time certain to obtain a bond after that? I'm not sure if that's completely clear or not.
Yeah, I don't really understand the question.
So the thought process is require no bond until the applicant and the Morgan Group can prove and submit applications for the permits that they have met all the criteria that are set by the, Mr. Lunt brought it up, obtaining all applicable permits from other agencies, et cetera. So I guess what I'm getting around is my thought process in this is to propose no bond until the applicant has received all permits from SwiftMud, DOT, whoever else they need to receive them, and then submits a permit request to the city of Tarpon Springs. At that point, the concerned citizens would have 3.5 weeks or whatever to produce a premium for a bond to protect whoever, the city and the applicant, of losses at that point.
So let me just jump in here and just make sure that we understand. So if the stay goes in place, and the stay would mean that they could not do anything further. So if it's going to be a partial stay, in other words, allow them to continue on with their applications with all state agencies, then you need to specifically provide that, because right now the motion to stay is to stop all actions relative to all permits. And so if you want to accept that out, we need that to be set out in the actual order. So it'd be a motion to stay in issuance of city permits, but not necessarily a stay on the other permits.
Okay, so the way it currently reads today, to stay on all permits, state agencies and things along those lines.
Yeah, I'm just going to go ahead and read.
So make sure I understand.
Yeah, I want to go ahead and read out loud the prayer for relief and the motion to stay, and then you can see exactly what they're asking for, and that's what the board is considering. So it's in the last paragraph on page 13 and 14, and it reads, "As such, concerned citizens respectfully request the commission as a lower tribunal in this proceeding, 1, stay the enforcement of Resolution 2021-52, Ordinance 2021-15, and Resolution 2021-60, that's the one that you were referring to, and 2, stay the issuance of any building permit, tree removal permit, certificate of occupancy, or any other permit, contract, land use approval, or any other approval from the city relating to the Anclote Harbor project until the disposition of the petitions." So that's the request. It's basically an all-out stay.
Okay, from the city itself.
Sorry, if I clarify, I mean, the
Hang
permits-
on, Ms. Graham. Two attorneys are up at the podium at the same time. I'm going to need some help from Mr. Trask on this procedurally.
So you've closed the public hearing, and I'm answering questions from my client, one of my commissioners.
So,
right, we're done with the public hearing portion of it.
all right.
Yeah.
Thank you, Mr. McLaren, Ms. Graham.
We agree.
I think
We're not-
actually agreeing on something.
You agree? Thank you.
We agree to disagree.
Does that mean y'all
Wanna go
can sit
ahead?
down again? I'm not sure.
They've agreed to sit down.
State what you think.
It's your option, Mayor.
Go ahead, Mr. McLaren.
My understanding, and, is that the request is to prevent the city from acting on any applications for city permits. I don't think there's a request here to prevent us from applying or receiving permits from state agencies. I think
You're
that's-
stating that for the record?
I believe that's for the record, and I
Okay.
think Ms.
Well,
Graham would agree
and
with me.
Ms. Graham, if you could state the same and that you agree as well for the record?
Yes, Commissioner, excuse me, Mayor, I do agree with that, and the reason why is because you would not have jurisdiction to.
Okay.
stay
Thank you
such a
both.
thing.
Okay, there you go.
Thanks, Mr. Trask.
I appreciate all the attorneys' input on that one. Okay, so my thought process behind this is that I understand the stay until the state agencies and things come into play. I think at some point, there needs to be some type of protection in place for the city and for the applicant. I understand the risk, and those are good points that were brought up by the public as well, too. So I would say number two, a hybrid of number two, would be a grant to stay with no bond until all permits from agencies outside of the city were met and then were submitted to the city. At that point, the concerned citizens would have 3.5 weeks. I'm not sure what the typical permit review would be, but 3.5 weeks to obtain a premium for the bond and show proof of a bond at that point.
Okay.
That's my suggestion.
Thank you, Commissioner Carr. Commissioner Eisner.
I wish to say nothing at this point.
Okay. Commissioner Kulyas.
Thank you, Mayor. City Attorney, I have a few questions. Is this a quasi-judicial or evidentiary hearing right now?
I would not consider it a quasi-judicial hearing. It is an evidentiary hearing because of the fact that you've been receiving testimony and evidence under oath.
Okay. Are the affected parties the same from the previous board, or does this board decide who the affected parties are currently?
It's not an issue in this
Okay.
particular matter.
If this all goes to court, the city of Tarpon Springs is sued, this current board will be deposed, and will the previous board be deposed?
It all depends on what the lawyers want to do. They may ask for other people to be deposed, but it's not necessarily something that's a given.
Okay. We did have our other litigation attorney, Jay Daniel. He did advise that, this is just an unprecedented situation. It's unique all around. For all parties, for where we're at now, it's special. This obviously hasn't been seen before. Mr. Daniel did also state that we as a board, we have wide lateral movement and options. From some of the testimony I heard from Morgan Group, I was disappointed from the lack of not having experts, consultants, engineers, land planners here to help articulate the next phases of the project, the lengths of them, and costs associated with them, because that's what we're here to talk about, is mitigation of loss. And for the record, I did get a response back from our city attorney Friday afternoon, about 3:30 to 4:30 p.m., that Mr. Ed Armstrong did reply back why the land planner was needed for the project, in which I did reply back early Saturday morning. So I do believe there was ample time, and I do believe that everyone was well aware of what hearings we were having today and last Tuesday. the city of Tarpon Springs is not stopping, in my opinion, anyone's constitutional right to build or say you can't. I think this is a process that's pretty much saying, let's wait and see. And I believe we should go with, and I don't know if we can, with a way of granting the stay, seeing if all the bonds or all the permits are issued, then having another meeting here to decide if there will or won't be a bond. I think it's the best way for the city to create and, mitigating losses and talk about how soon things can happen. Because right now, if we do that, I believe the ball is in Morgan Group's court. They will try to do everything they can to obtain the permits that they need to in a timely manner. And maybe we can and then have a discussion back here on should there be or shouldn't there be a bond. So that would be my recommendations. And I don't want to necessarily say that once the permits are granted that there definitely has to be a bond. I'd like to have another special meeting, whatever the legal public interest is, to be able to notify everybody and come back here again. So that's all I have, Mayor.
Thank you, Commissioner Krios. Commissioner Eisner, you're still without comment?
Correct.
Okay. First, let me say I'm not a gambler, and we're asking to gamble tonight as far as setting a bond, predicting whether the courts will rule in 2 days, 6 months, 18 months. There's, in my opinion, conflicting information that we received, and many of the experts that could answer those questions, including agents of those state and federal regulatory divisions, were not present tonight. So it's hard to say where we are in this process. I'm not concerned about a lawsuit. I've dealt with some pretty large lawsuits with the city, one in particular, and I'm not concerned about that until we get to that point. I don't know that we will get to that point. And also, the one thing I said last time, which I still really believe wholeheartedly, that I'm here for the public interest, and that this discussion has largely been about money. And I know that we've talked about the environment, but I'm also very sensitive to the people that are on US 19. I've said that publicly, so that's nothing new here. So I do feel that there's a public interest element in this matter. I also think that there is a way to cross or pretty much proceed in a fair way to both parties without causing any angst on either side, and then also to let the courts deal with this matter, and then we'll find out what the ultimate decision is. And unfortunately, and I don't know whether the timing of the courts and bonds and things like that are going to coincide. But in the meantime, what I would like to do is approach this, and I've given this some thought, and also I've had conversations with Ms. Vincent, not even involving this bond hearing, in past times with when would we be required to issue a construction permit. And it has to go back to that Florida state statute that says that the city can't hold up a construction permit or a building permit from the city because SwiftMud hasn't issued its permit or the Army Corps hasn't issued its permit. And what Mrs. Vincent provided me was, in the wisdom of our staff, they built in protection in that development order. The development order, actually Resolution 2021-60, that was the approval of the application, and they provided several conditions in that, and that also includes the outside agencies. It doesn't allude to the bond, the process of the stay, whether state agencies should stop. I doubt that they do anything we'd say anyway, but it's very specific that we issued this resolution in cooperation with the Morgan Group and the commission, the three that actually voted for the project. And the provisions in there are fairly comprehensive, and they go beyond the state and federal permits. So what I would like to do, and that is the one thing that is an absolute in this matter, are those conditions. And there's approximately 7 or 9 conditions in this resolution which the residents don't have, and it's certainly not in the backup, but it's items 4, 5, 7 through 13 of Section 4 of the resolution. And the approach that I would like to suggest this evening to kind of make sure that we sweep everything up, the federal permits and anything else that the staff may need, which is already part of this resolution that, in effect, Morgan Group has agreed to, is resolved prior to any city permits being issued. And so what I'd like to do is take the approach, at least suggest to the commission, that that we take the approach that a bond is not required before the date that all of the items, as I mentioned, 4, 5, 7 through 16 of Section 4 of Resolution 2021-16 are verified complete by the city staff. And at that time, the city commission would meet again within 7 days of that date to reconsider a bond. And I think from the standpoint, again, I'm not an attorney, that's the safest approach that I think we could take from both the public interest and also from the Morgan Group. I see Mr. Armstrong getting up.
May I ask a question, Mayor? Ed Armstrong. I'm an attorney with the law firm of Hill Ward Henderson, 600 Cleveland Street, Suite 800 in Clearwater. I was listening very carefully, sir. I'm not certain. Is what you're saying an attempt to modify the approvals that were granted previously by the commission?
No.
Okay, so they stand exactly as they always have when approved. Is that correct?
We're not modifying Resolution 2021-16. I'm simply tying the requirements of the conditions of Resolution 2021-60 as a condition for issuing, to make a determination of when the commission would come back and reconsider the bond at that time. In other words, at that time, you would have all of your state, federal permits in hand. You would have whatever else is needed from the standpoint of that's required in here, and that at that time the staff would deem it to be complete.
Right. Yeah, we're going to have to object on the record. We believe that is a change of the terms of the granted approvals, and we're objecting on the record. Thank you.
Okay.
Mayor.
Hang on a second, Commissioner Carnes. Let me just think about this a second. All right, go ahead.
I was gonna say, I think you have at least 3 of us that are, I'm aligned with what you're saying. My thought process was to set a bond tonight so we don't have to meet a second time or a third time. But I understand what you're saying. That's fine with me. It's aligned with what my thinking is on this too. And I believe there's another commissioner that's somewhat aligned with that as well. So I would say, let's go for a motion then.
Right. The problem with setting a bond tonight is that we don't know the amount unless we start guessing as far as this
Understood.
timeframe goes. What I want to do is, are there any other commissioners that have any comments that they want to make in this regard?
Yes, Mayor, I just want to, after clarifying with both attorneys and speaking on this matter with the rational basis that would be used, it does give many aspects, and it's more wide open unless our city attorney wants to correct me on issues including but not limited to the public interest, from safety, road hazards, all types of stuff. That's why I wanted to make sure they did state that the rational basis would be their route to go. And, this whole project is probably one of the reasons why you have this eclectic bunch that you have up here right now. And so, but we also want to protect the city. We want to do what's right. We don't want to make sure we're not hindered from being able to do capital improvement projects down the road to help to shape the city. But I do hear from a few of the commissioners that there is a safe approach to make sure that there's no, all sides are heard and all sides have to take action when needed. So, thank you, Mayor.
Thank you. What I'm going to do is, I need to have a 10-minute recess. I need to discuss, is Ms. Vincent still here? She's not, okay. That's okay. I need a 10-minute recess to discuss this with the city attorney. I'm going to adjourn for recess now at 9:33. And we'll Our meeting is reconvened at 9:42. Obviously, I spoke to both the city attorney and city manager on this, and I want to make it clear for the record, or whatever we want to describe it at this point, that we're not changing any of the conditions of approval. We're allowing the Morgan Group to proceed with anything that they're doing outside of the city of Tarpon Springs. There's no campaign on our part that we're going to seek putting a stay on that outside. And I note Mr. Armstrong's objection for the record, and I still believe that we should, in terms of a comprehensive approach to this, to make sure that there aren't any loose ends, that once these items are complete, then we would reconvene to, because that would be the earliest that the Morgan Group could pull a permit, regardless of whether their federal permits or have been issued or state permits have been issued. There's several other items up in here that have to be satisfied as well before a development permit, whether it's building, construction, or grubbing permit, is issued. And so it would still be in the resolution 2021-60, items 4, 5, 7 through 16 of section 4. I'm not including, actually, let me just go back. And I also asked the city attorney about 6. That's beyond us. So basically, it would be items 4 through 16 that that would have to be verified complete by the city staff, at which time the commission would meet again. And I think 7 days, and what I mean by that is 7 calendar days. We're a 24/7 operation here at the city, so 7 calendar days from that date to reconsider a bond. And I think that would, in my conscience, satisfy the issues that the concerned citizens have, and also address any concerns as far as risk or loss that the Morgan Group may have.
What are you looking for? Are you looking for a motion in that form?
Pardon me?
Are you looking for a motion in that form, or are you open for a motion now?
If you could hand that to Mr. Carr, Commissioner Carr. That's something I wrote down earlier today. That's something that basically I just described to make sure that,
Okay.
yeah, that would be the motion. And that, I'm looking for that motion unless, and we can try it and see what happens. If we don't want to bond, then we can do, not second the motion and there be another motion for no bond at all, or we can, make a motion for a bond and then go from there. First, let me ask, is there any other discussion? Vice Mayor Lunt?
I'm in concurrence with your train of thought
Okay.
here. I think it's a good plan.
All right, thank you.
Yeah, I've just got one comment to make.
Go ahead, sure.
The initial stay vote, I've still voted no for. I still didn't think that the concerned citizens met the requirement that was needed, but in this aspect, we need to figure out what we're going to do with the bond requirement, and I'm going to support what was discussed tonight here from the mayor and the other commissioners. So with that, I will make a motion to not require a bond in the time being until, and there would be a further, there'll be a new meeting set 7 days after the Morgan Group has supplied all the requirements in the resolution 2021-60, 4, 5, 7 through 16.
4 through 16.
4 through 16. Again, once that's done and submitted to the city, the commission will have 7 days to reconvene in a meeting to review if a bond shall be required by the concerned citizens of Tarpon Springs.
Second.
If I may get clarification, items 4 through 16, section 4 of the resolution.
That's correct. Part of the conditions, it's part of the resolution.
Okay. We have a motion and a second. Are there any commissioner comments? Do we go to public comment on this?
No?
Okay. Do we have any commissioner comments on this? Roll call, please.
Commissioner Kulyas?
Yes.
Commissioner Eisner?
Yes.
Commissioner Carr?
Yes.
Vice Mayor Lund?
Yes.
Mayor Vaticiotis?
Yes. Okay, that ends the item this evening, and I'm going to look at the agenda. I don't know that we have any. Let's go to staff comments. Are there any staff comments?
No
Chief Bell?
comments, sir.
City Attorney Trask?
No, sir, thank you.
City
No, sir.
Manager?
I have no comments.
Would you like to make a comment,
I
Commissioner?
can make a
please?
comment now. I want to thank City Manager. That was an excellent fireworks that you set up. I got nothing but good feedback from everybody, so you are commended.
Thank you very much. Okay. Vice Mayor Lunt, do you have anything?
Outside of the fireworks, I think both the city employee picnic and the picnic that was thrown for the city citizens were both stellar. They were out of scope, and it's good that everybody's sort of recovering from COVID and out and mixing around. It was great to see the kids having a great time, so thank you.
Commissioner Carr? Commissioner Kulyas?
It was a great Independence Day weekend for city staff, for the daytime, the park, and the fireworks display. It was amazing. Thank you, City Manager.
Thank you.
Yeah, it was actually a peaceful day for the most part, except for the fireworks every now and then and the dogs not being happy. But other than that, it was a very pleasant day, and I really don't have anything else. I just don't mind telling the residents that this is a pretty stressful time for the commission of inheriting a lot of this from the former commission, and we're dealing with it the best that we can in as fair a manner as we can to both parties. And I know there's going to be arguments one way or the other, but again, all we can do is the best that we're able to, and just keep looking forward. We've got the budget coming up with some challenges there, and we're going to focus on doing things for the residents in that one, and I feel really good about that. And we've got some other items, exciting items coming up pretty soon as well. So on that note, meeting adjourned at 9:50 p.m.